the Honorable, the Acting Chief Justice and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Will the clerk of court please call the case?
Scheduled for today's oral argument is case GR number 217910. Jesus Ricardo Falces III petitioner versus Civil Registrar General Respondent, LGBTS Christian Church Incorporated, Reverend Crescencio C.J. Agbayani Jr., Marlon Felipe and Maria Arlene Sugar Ibanez, petitioners in intervention.
Please stand up, the petitioner's counsel.
Your Honors, respectfully appealing for petitioners and petitioners in intervention.
In addition, we have Attorney Fernando Perito for intervenor, and attorneys Ronaldo T. Reyes and Jeremy Jaimay Gatdola, intervenors, oppositors. Appearances. Counsel for petitioner, Attorney Jesus Ricardo M. Falces III, Attorney Alfredo Molo III, Attorney Aldrich Fitz D., Attorney Darwin Angeles, Attorney Keisha Trina Guanco, kindly stand up, Attorney Christopher Ryan Maranan, with Attorney Angeles arguing on the procedural issues for 6 minutes, while Attorney Falces III on the substantial issues for 14 minutes. Counsel for the respondent, Office of the Solicitor General. Solicitor General Jose Calida, Assistant Solicitor General Rex Bernardo Pascual, Assistant Solicitor General Hermes Ocampo, Assistant Solicitor General Raymond Rigodon, and Assistant Solicitor General Peñafrancia Dieza. For intervenors, oppositors, Attorney Fernando Perito, Attorney Ronaldo Reyes, and Attorney Jeremy Jaimay Gatdola, with Attorney Perito and Attorney Gatdola arguing for 10 minutes each. Your Honors.
Counsels. The first counsel for petitioner may now approach the podium to make his presentation.
May it please the court, may I proceed? Honorable Chief Justice, Associate Justices of the Supreme Court, good afternoon. Petitioners come before this honorable court to pray for a judgment of unconstitutionality against Articles 1, 2, 46.4, and 55.6 of the Family Code for violating the fundamental constitutional right to marry held by lesbians, gays, bisexuals, and transgenders in the Philippines. Settled jurisprudence recognizes that the right to marry is one of the most cherished and basic rights of any person. The Honorable Court affirmed this no less than 2 months ago in Republic v. Manalo. It is an associational right founded on the universally recognized liberty of every human being to associate with anyone anyone whom his or her heart so chooses without any interference from the state. In Republic versus Albios, the Honorable Court ruled that it is not within the powers of the state to dictate on the kind of life that a couple chooses to lead, and any attempt to regulate their lifestyle would raise serious constitutional questions. As will be explained by my co-counsel later, in words that can only come from a person so aggrieved, the assailed provisions of the Family Code unjustly deprive him and our clients of their fundamental right to marry solely on the basis of their gender. The law deprives them of a right inherent in every human being. Petitioners Agbayani, Felipe, and Ibanez applied for a marriage license before the office of the local civil registrar. They possessed all the requisites of marriage, they were of legal age, capable of giving consent to the marital bond, and would have looked forward to appearing before a solemnizing officer to take each other in love as spouses. They would have been granted a marriage license if not for the fact that they were of the same sex. Thus, Your Honors, the instant case presents an actual case and controversy. Petitioners Falsis, Agbayani, Felipe, and Ibanez speak as specific relief concerning the enjoyment of their right and their very legal status, that is, the recognition of their fundamental right to marry. It is this undue deprivation of petitioners' fundamental right that is at the heart of this case. In resolving the petition, the Honorable Court is not being asked to render a hypothetical opinion, but rather to decide what rights our clients have, which hinge on the question, does the state have the power to deprive LGBTs of their fundamental right to marry? This is a case of first impression involving the very definition of the right to marry, thus justifying our direct recourse before the Honorable Court. In Diocese of Bacolod v. Comelec, the Honorable Court ruled it is this court's constitutional mandate to protect the people against government's infringement of their fundamental rights. This duty is highlighted by the Honorable Court's expanded certiorari jurisdiction under Article 8, Section 1 of the 1987 Constitution. It is this very jurisdiction and mandate that is being invoked by the petitioners in this case. As a fundamental right, any law that infringes on the right to marry triggers strict scrutiny. In White Light Corporation versus City of Manila, a law under strict scrutiny is unconstitutional unless it can be shown that 1, it is justified by a compelling state interest, 2, it employs the least intrusive means to protect such interest, and 3, the means chosen is narrowly tailored. We submit that the Family Code fails these standards. First, the assailed provisions of the Family Code are unconstitutional, Your Honor, because there is no compelling state interest to be served. The Solicitor General does not prefer any such interest in the pleadings. Even assuming there is any state interest in limiting marriage between a man and a woman, such interest cannot be pursued without running afoul of the Constitution. The 1987 Constitution never envisioned marriage as being between a man and a woman. There is absolutely no language in the 1987 Constitution or any of our republic's previous constitutions that imposes a gender restriction in order for Filipinos to marry. In imposing a limitation on marriage not contemplated by the Constitution, the Family Code transgresses it. Thus, it is the Honorable Court's duty to strike down the law so that the Constitution shall prevail. Second, the Family Code also fails to employ the least intrusive means to protect the state's interest. We assert, Your Honor, that whatever interests sought to be protected by the state can be adequately protected by any regulation that is not as oppressive than the total disenfranchisement of LGBT persons. Third, the Family Code's prohibition against marriage of LGBT persons is not narrowly tailored to protect the state's interest. In Spark versus Quezon City, the Honorable Court ruled that governmental action fails strict scrutiny if it overly restricts other fundamental freedoms. The prohibition on same-sex marriage, we submit, Your Honors, deprives LGBT couples of the right to privacy, right to found a family, right to rear children, right of association, and other basic rights. These are fatal to the law's constitutionality. The instant case raises serious constitutional questions, barring the political question doctrine. We submit that the question is simple, Your Honors. Does the state have the power to deprive LGBTs of their fundamental right? In Antonio v. Reyes, the Honorable Court ruled that while it is within the province of the legislature to define the legal aspects of marriage, any legislative act must adhere to the Constitution and the Bill of Rights. Thus, in Diocese of Bacolod, the political question doctrine can never bar the Honorable Court from exercising its power of judicial review when the act of a constitutional organ infringes upon a fundamental right. The petitioner's locus standi is beyond doubt. Petitioners Agbayani, Felipe, and Ibanez have a personal stake in the outcome of the case. Precisely this case arose because the state denied their applications for marriage on the basis of this oppressive law that limits marriage between a man and a woman. In closing, Your Honors, petitioners ask the Honorable Court to rule for marriage, to rule for love, for to love is to be human. We are simply asking Your Honor for the freedom to love. I now give the floor to my co-counsel and petitioner, Attorney Jesus Faces, who will continue the petitioner's opening statement and discuss the substantive issues. Thank you, Your Honors.
May it please the Court, to the Honorable Chief Justice Antonio Carpio, to the Honorable Associate Justices of the Supreme Court, and to all Filipino families, we wish everyone a loving afternoon. According to this Honorable Court, in the case of Antonio versus Reyes, the Constitution does not establish the parameters of state protection to marriage. It remains the province of the legislature to define all legal aspects of marriage. However, subject to the qualification that such law itself adheres to the Constitution and the Bill of Rights. The 1935, 1973, and 1987 Constitution of the Republic never discriminated against same-sex couples textually. Only the statutes do. We submit that the text of the Constitution is clear. Marriage as an inviolable social institution is a foundation of the family. Nothing in Article 15 or any other provisions of the Constitution limits the definition of marriage as only between a man and a woman. But something in the Constitution commands that marriage under the family code be extended to lesbians, gays, bisexuals, or transgender couples. When the Constitution says no person shall be denied equal protection of the laws, and that the state values the dignity of every human person, the Constitution requires any couple, regardless of their sex or gender, to be recognized as having the right to marry, because they are similarly situated, because any couple needs marriage to serve as the foundation of their family. And so we must ask, what is marriage? The freedom to choose her status, which is a privilege that inheres in her as an intangible and inalienable right. This is how this Honorable Court has characterized the right to marry in the case of Cadiz versus Brent Hospital. Without the right to marry, people are denied the freedom to choose their status. Petitioners, especially partners Crescencio Agbayani and Marlon Felipe, Sugar Ibanez and her partner who wishes to remain anonymous, and myself are all denied the freedom to choose our status, the freedom to choose to remain single or to become married. We are forced and condemned to live out the rest of our legal lives as single. Intervenors CJ and Marlon, for example, have been together for more than 12 years. They met and fell in love like any other couple, but they also got married under a religious ceremony, though, by the Metropolitan Community Church, an LGBT-affirming Christian denomination. Since then, they have deported themselves as spouses, husband and husband, to their friends and families. Together, they have lived under one roof, paid their bills, and shared their struggles. One struggle they had to share was when Marlon, who is a public school teacher, was accused of being immoral in his workplace. Some people heard he was gay and living together with his partner. Despite the fact that they got married under a religious ceremony, he was accused of immorality, and he could not show people that it was okay, for he could not and he was not legally married. Fortunately, in his workplace, there were good people who did not mind. However, they are growing old and getting older. They worry about a lot of things other married couples worry about, but don't worry right now because they are married. Does my partner have a right to my government benefits? Will my partner be allowed in the hospital to make decisions for me? Does my partner have the legal right, nay, duty, to make funeral arrangements when I pass away? That is why on August 3, 2015, interveners tried to apply for a marriage license before the Quezon City Civil Registrar. But they were not even entertained. They were denied outright. And this is not an isolated case among LGBT couples. Just last June 7, Pastor Jason Masaganda and Lester Buddy of the Metropolitan Community Church also tried to apply for a marriage license but met the same fate. Marriage is a bundle of legal rights and obligations. It comes as a gift that allows couples to have peace of mind, that they will be legally recognized as spouses because they have the freedom to choose their status. This honorable court, in the case of Imbong versus Ochoa, explained that the right to chart their own destiny together falls within the protected zones of marital privacy, and such state intervention would encroach into the zones of spousal privacy guaranteed by the Constitution. Justice Hardilesa, in his concurring opinion in the case of Cadiz versus Brent Hospital, has said that the decision to marry and whom to marry are two of the most important choices that a woman or man can make in her life. The decision to marry is transformative. If we were to borrow a foreign jurisprudence which is only persuasive, Justice Kennedy said in the case of Obergefell versus Hodges, marriage transforms strangers into relatives, binding families and societies together. Legally, intervenors Crescencio Agbayani and Marlon Felipe are strangers to each other, forced to live the rest of their lives as legal strangers, and that is the infringement on their constitutional right to marry. What are petitioners asking from this honorable court? In the very recent case of Republic versus Manalo, this honorable court, speaking to Justice Peralta, explained that the right to marry is a fundamental right whose infringement would trigger strict scrutiny. In that case, this honorable court found paragraph 2 of Article 26 of the Family Code to be violative of the Equal Protection Clause. But instead of striking down the law, this honorable court adopted a liberal interpretation. We ask this honorable court to similarly rule in this case. A liberal interpretation of Articles 1 and 2 of the Family Code, where LGBT couples are extended to have the right to marry, is justified under the doctrine of constitutional supremacy, where the Constitution is deemed written into every statute, including the Family Code. And this was most recently affirmed in the case of resident marine mammals of Canyon Strait versus Reyes, citing Manila Prince Hotel versus GSIS. Given the infringement of a fundamental right, the Articles 1 and 2 of the Family Code is presumed unconstitutional. It is now the state which has the burden of proof, not the petitioners. Regardless of the presumption, though, we offer 3 arguments why the exclusion of same-sex couples is unconstitutional. 1, it deprives petitioners of the right to marry without substantive due process. 2, it denies petitioners of equal protection of the laws. And 3, it violates the religious freedom of petitioners. On the first argument, there is no compelling state interest to limit marriage as only between a man and a woman. The Solicitor General, in its 2 comments, has not preferred any reason at all or a compelling state interest that may exist to exclude LGBT couples from the institution of marriage. At most, they have only erected procedural niceties or technical obstacles that can be brushed aside based on the substance. In fact, on the flip side, Your Honors, we argue, petitioners submit that there is a compelling state interest for LGBT couples to be included in the institution of marriage. Marriage as the foundation of the family does not only contemplate a nuclear family, where you have the traditional model of a mother, a father, and a child. A family founded by marriage under the family code also includes a family set up without children, even by heterosexual couples, where the spouses are the only ones who constitute the family. That is why the family code itself says that marriage is indeed a special contract for the purpose of establishing a conjugal and family life. LGBT couples with or without children constitute a family too, and so should have access to marriage to serve as their foundation. On the second argument, the legislative classification under the family code does not rest on substantial distinction, is under-inclusive, and at the same time over-inclusive. In the case of Mosqueda versus Filipino Banana Growers and Exporters Association, this honorable court, speaking to Justice Bersamin, explained that strict scrutiny applies when a legislative classification impermissibly interferes with the exercise of a fundamental right or operates to the peculiar class disadvantage of a suspect class. The Family Code's exclusion of LGBT couples not only infringes on the fundamental right to marry, but it is also a suspect classification because the four factors laid out in the case of Angladlad versus Comelec are all present. History of invidious discrimination against LGBTs, ability to contribute to society which has no relationship to the law, immutability of distinguishing characteristics which we did not choose to be LGBTs, and political power of LGBTs. There is no substantial distinction. Same-sex couples, just like opposite couples, can and do establish a conjugal and family life, as demonstrated by intervenors. A conjugal and family life means a life of togetherness. A conjugal life itself means companionship, even according to the authors of the Family Code, such as Justice Romero and Judge Sempio D. Black's Law Dictionary defines family as a collective body of persons who live in one house and under one head or management. There is nothing sex-specific in achieving the purpose of marriage under the Family Code, establishing a conjugal and family life. A family founded by marriage under the Family Code, as has been said, also includes a family set up by opposite-sex couples who do not have children. Sterile couples are also allowed to marry under the Philippines, given that procreation is not a requirement under the Family Code before or after getting married. Thus, denying LGBT couples the right to marry would make the legislative classification under-inclusive. Assuming children are necessary, Your Honors, to be considered a family, the Family Code's classification would then be over-inclusive. Anyway, Your Honors, current adoption laws allow homosexuals, although individually, to adopt. The fact that LGBT couples cannot jointly adopt is another consequence and injustice of the denial of their right to marry. This is a sad consequence for not just LGBT couples, but also for thousands of orphan children. Petitioners are not unaware that this honorable court has also said in the case of Biraogo versus Truth Commission that mere under-inclusivity or mere over-inclusivity is not fatal to the constitutionality of a law. However, this court also said that when there is deliberate, purposeful, and intentional discrimination, the Equal Protection Clause is violated. Here, Your Honors, the animus cannot be any clearer when homosexuality or lesbianism is lumped together with drug addiction as grounds for annulment or legal separation. The identities of LGBT people are associated as negative traits. Thus, the Equal Protection Clause is violated for the legislative classification of opposite-sex couples lacks substantial distinction as against same-sex couples. On the third argument, violation of the religious freedom of petitioners. Intervenors CJ, Marlon, Maria, and her partner are Christians. Christians who sincerely and with all conviction believe that homosexuality is not a sin. And flowing from that fact, but aside from that, from the Bible itself, they believe in their own interpretation of the Bible that it does not prohibit two men or two women from marrying each other. They in fact have married each other under religious ceremonies, Metropolitan Community Church, and other LGBT-affirming churches. Under Article 15 of the Family Code, of the Constitution, petitioners have a right to found a family in accordance with their religious convictions. The Family Code, by excluding LGBT Christian couples from marriage, has placed an undue burden on their religious freedom by failing to legally recognize their relationship as well. Your Honors, if I may request for additional time, Your Honors.
Okay, 5 minutes.
Thank you, Your Honors. And so, to close this speech, when the right to marry, a decision so personal, so intimate, and so life-changing, is denied to LGBT people, the state is not valuing their dignity. No group of people who are endowed by their God or Creator and recognized by the Constitution to have dignity and equality should ever be treated as second-class citizens in their own land. We are aware some Filipinos may not support same-sex marriage, especially those who oppose for religious reasons. But to quote Justice Kennedy, and we are aware that this is only persuasive, religions and those who adhere to religious doctrines may continue to advocate with the utmost sincere conviction that by divine precepts, same-sex marriage should not be condoned. In turn, those who believe allowing same-sex marriage is proper or indeed essential, whether as a matter of religious convictions like intervenors or secular belief like myself, may engage with those who disagree with their view in an open and searching debate. The Constitution, however, does not permit the state to bar same-sex couples from marriage on the same terms as accorded to couples of the opposite sex. From the United States to Ireland, many religious countries recognize same-sex marriage because they believe in equality and in people's choices. Our country is no different. We are a Christian nation, yes, but we are also a secular republic. This honorable court, speaking to Justice Del Castillo in the case of Angladlad versus Comelec, said, "One unavoidable consequence of everyone having the freedom to choose is that others may make different choices, choices we would not approve of ourselves, even choices that may shock or offend or anger us. However, choices are not to be legally prohibited merely because they are different. We are different, Your Honors, but we are still also human beings who love and are loved. Like other Filipinos, LGBT couples are families too." Thank you for this honorable court's time.
The members of the court will interpellate the two counsels, Justice Marvick Leonen.
Attorney Falsis, can you take the podium?
Your Honor.
I see that you are now properly attired for the court.
Yes, Your Honor.
And of course, I hope you learned your lesson from the preliminary conference.
Yes, Your Honor.
Now, you realize, of course, that this is a very dangerous case that you brought. It's dangerous to the movement that you apparently seem to have brought here, whether or not they had consent, because you are now going to put squarely for this court, the Supreme Court of this Republic, an issue which will require a very intimate reading of the provisions of the Constitution. You're aware of that?
Yes, Your Honor.
You're also aware that in many jurisdictions, before same-sex marriage was brought to their Supreme Courts, the United States included, Europe, Australia, that there were a lot of political battles that were waged in political forums, such as their parliaments, their congresses, their churches, their corporations, etc. Correct?
Yes, Your Honor.
And in this particular case, do you think that the movement now, the feminist movement here in the country, the LGBT movement here in this country, and the movements that are simply asking for recognition of various identities, that the political maturity of both the movement and the institutions of law are now ready to accept the nuances of your arguments?
Your Honors, if we may explain, about the movement.
Not the movement. I'm just asking whether you think that the political infrastructure is already there.
Yes, Your Honor, we do.
And in all cases where same-sex marriage have been argued in any court in this planet, they have always gone up against a patriarchy, correct?
Yes, Your Honor.
Heteronormativity, correct?
Yes, Your Honor.
Yes, and maybe in some instances, like some countries in Europe and perhaps even in the Philippines, the dominance of religious faiths and religious morality. Is that not correct?
Yes, Your Honor.
Yes, and you realize, of course, that your arguments of intimacy or your arguments of choices of intimate relations will be taken into consideration in the context of that, let us say, a cultural hegemony. Is that not correct?
Yes, Your Honor.
Yes.
If we may add that it will also be considered under the constitutional hegemony.
Well, there's no such thing as constitutional hegemony if you know what hegemony really means. And then on the other hand, that cases such as this require a very clear understanding of certain concepts. For example, the difference between sex, whether assigned or reassigned, gender identity, gender expression, and of course, sexual orientation. I will just cover four of those later on. But you are, of course, by bringing this case, you are trusting that the Supreme Court and, of course, the various infrastructure in our chambers, our staff, our lawyers, understand the various nuance between sex, gender, gender identity, gender expression, and sexual orientation. Correct?
Your Honor,
Because God help you, if the court, if the public is not ready to accept the nuances or to understand these nuances, then we may commit a mistake, and such a mistake might be permanent in terms of the very everyday intimate relations and the clamor for status of various people that are represented by the movement that is seated at your back. Correct?
with Your Honor's indulgence, the political infrastructure, the petitioners are of the belief that some Supreme Court decisions...
Not the political infrastructure, but the understanding of this issue must be so nuanced because, as I said, do you realize that you are going up against a very powerful heteronormative culture in this country?
Yes, Your Honor.
Yes, and I hope you're ready for that.
Yes, Your Honor.
Yes, and we will see. Okay. Now, and you trust that this court has the openness to listen, correct?
Yes, Your Honor, definitely.
Notwithstanding our own various intimate relations. Is that not correct?
Yes, Your Honor.
That it will not creep into our understanding of the legal issues that are involved.
Your Honor, yes.
Yes, okay. So, and of course you understand that whatever ruling this court gives, whether or not to grant your petition and for whatever purpose or whatever reason, is not a reflection of how we regard those that are wishing to have same-sex relationships or who have a different identity, gender identity as ours.
Yes, Your Honor.
And therefore that you trust that this court on this issue is going to simply rule on the merits of the Constitution, its provisions, as well as the context, the proper constitutional interpretative methodology that we think is appropriate. Is that not correct?
We trust this court so much, Your Honor.
Yes. Really, so much. So much.
Yes, Your Honor.
That you are willing to accept a denial of your petition later on, just in case.
That is the consequence of democracy, Your Honor, and our rule of law.
Well, that's a good attitude to take because there are some that have been defeated by this court that give other reasons other than trusting the interpretation of this court. Okay. Also, you realize that it is your burden to prove to this court the unconstitutionality of the provisions that you have cited, as well as the interference, abridgment, or denial of the constitutional rights of yourself and of your client. You carry the burden. Is that not correct?
Yes, Your Honor, with the indulgence of Your Honor. I
Yes,
believe
so you
that we
carry
have
the burden.
discharged.
And you have to go through 4 levels. In accordance with how the pleadings have been filed, there are now 4 obstacles that you have to hurdle. Some of which, of course, you have raised. The others were joined as the Solicitor General filed its comment and its supplemental comment. The first one is justiciability, correct?
Yes, Your Honor.
Because as far as the first petition was concerned, that was filed by you. Is it not correct?
Yes, Your Honor.
And you do not have a partner. Is that not correct?
I do not have a partner.
And yet you claim that there is an abridgment of your right to marry. Is that not correct?
Yes, Your Honor.
And there was an intervention, but in the intervention it carried the experience of a couple that tried to get a marriage license. Is that not correct?
Yes, Your Honor.
By the way, just so we can put a face to the parties, are the intervenors, which you also represent, here present?
Yes, Your Honor.
Can you kindly ask them to stand up so we can identify them? Okay. Oh, there's 3.
The petitioners Crescencio Agbayani and Marlon Felipe,
Yes.
and Maria Sugar Ibanez, but her partner wishes to remain anonymous, Your
Okay. We will respect that. Thank you. I thought we were going to talk about polyamory, but not yet, okay?
No, Your Honor.
Not yet. Although I will have certain questions in relation to that at a certain point, okay?
We expect
And a bit serious question later on, okay? So justiciability is something that you will hurdle, and I think that you are very well aware of the issues that were raised in relation to justiciability. The second thing that you have to hurdle is the nature of this right to marry. On the one hand, you claim, the petitioners claim, that it is a fundamental and constitutional right. On the other, the Solicitor General takes the position that it is a right, yes, but it is a statutory construct, which means that the right to marry may be there, but it needs to be clarified in Congress rather than in the court. Is that an accurate portrayal of the issue?
Yes, Your Honor.
Yes. And of course, the Solgen takes also a dangerous position for your side because it actually argues that the constitutional provision which says marriage founds a family only refers to a male and a female, an opposite sex relation. That's the other position that the Solgen is doing, correct?
Yes, Your Honor.
And if this court adopts that second position, then even same-sex relationships will no longer be a political question. It will not be able to pass any bill in the House or in the Senate because the Supreme Court might say, if it agrees with part of the argument of the Solgen, that marriage is only for same-sex couples constitutionally. Is that not correct? That's the risk you're taking.
Yes, Your Honor. However, we have certain qualifications if that would happen, Your Honor.
Okay? That's why I said this is a very dangerous case for your movement. Okay. Third is, even though there is such a thing as an inherent constitutional fundamental right to marry, that you will have to show and clearly and convincingly to this court that it breaches any one of the constitutional limitations of government. The first one being due process, the second one being equal protection, and the third one being religious freedoms. Is that not correct?
Yes, Your Honor.
Yes. And in terms of religious freedom, just to be clear, your argument is your right to express a religious belief is violated by the provisions on marriage, correct?
Yes, Your Honor.
It is not taking a position that the provisions on marriage found in our civil code entrenches or establishes a religious belief.
No, Your Honor. That
So
is
it's
not
just the only free expression, not non-establishment.
free expression, Your Honor, in relation, especially as well in Article
And therefore,
15.
some of the words or some of the sentences which could be interpreted in this regard, in some of the in the petition for intervention especially, on the non-establishment violation is not correct. We are limiting ourselves to freedom, the freedom to express one's religion. Is that not correct?
Yes, Your Honor, there's no argument on non-establishment.
Okay, so that's the third. And finally, considering that there are many heterosexual couples that have actually taken the vows of marriage, you are now asking the court in your prayer, in your pleadings, to declare as null and void the provisions which actually allow heterosexual couples to marry. Is that not correct?
With the indulgence of this court, we would like to qualify that prayer, Your Honor, or relief.
Because if that is done so, then you are therefore saying that you want to dictate a kind of intimate relation also on others.
No, Your Honor.
So what is your prayer?
The prayer of the petitions, Your Honor, initially says that to declare Articles 1 and 2 of the Family Code as null and void. However, we also prayed for other just and equitable reliefs, which we are of the position that in relation with Republic versus Manalo, that there is an alternative option for this court in the exercise of its expanded power of judicial review to, in the light that the provision is
Wait a
found.
minute. You're saying or you're claiming that the proper reading of Republic versus Manalo under the ponencia of Justice Peralta is that there is an alternative to finding, there's an alternative consequence to a finding that a provision is unconstitutional. Normally, if a provision is unconstitutional, it is void ab initio.
Yes, Your
And
Honor.
you are now saying that the court has created new jurisprudence in Republic versus Manalo that when we find a provision to be unconstitutional, that it can be valid.
No, Your Honor, what petitioners are saying that our interpretation of this court's guide in Republic versus Manalo is that
So in essence, you are asking the court to find or to found new jurisprudence in relation to situations like yours.
no, Your Honors, we are only asking for a statutory interpretation that was applied in Republic versus Manalo, that versus two interpretations that would lead to finding of unconstitutionality. The court adopted a liberal interpretation, did not declare Article 26, paragraph 2 as unconstitutional, but because the Constitution is deemed written into the Family Code as well, interpreted it in light of the Equal Protection Clause.
As a matter of fact, this was also mentioned in a concurring opinion in Garcia versus Dillon. Is that not correct? That was on battered men and the possibility that in a future case, not in that case, that there can be a man, a biological male, who will file or ask that they be protected under Vow C, but it was just a concurring opinion. Is that not correct?
Yes, Your Honor.
So your claim now is that it has found unanimity in the court in Republic versus Manalo. Well, not really unanimity. There was a dissent in Republic versus Manalo. Correct?
Yes, Your Honor.
How many dissents were there in in that case?
One joined by two justices, Your Honor.
Who dissented? Because you were mentioning names of justices a while ago, so I think you are a very astute observer of the court.
I would not claim, Your Honor, that, but to answer the original question, the dissenting opinion was by Justice Caguioa, joined by Justice Bernabe and Justice Del Castillo.
It was a very well-reasoned out decision, almost convincing to the majority. Was that not correct?
Yes, Your Honor.
Yes, okay. Now, before we proceed, and just to be very clear about this, you mentioned an American case. What is that American case?
I mentioned two American cases, I think, Your Honor.
Under the pen of the American Justice Kennedy, you mentioned that case.
The case of Obergefell versus Hodges, Your Honor.
Yes. Now, just to be clear, what is the status of American cases to this Supreme Court?
Your Honor, it's only persuasive. It is
As
not
persuasive as
controlling.
jurisprudence of South Africa or Nairobi or Papua New Guinea or Europe or the European Court of Human Rights. Is that not correct?
Yes, Your Honor.
Yes. Insofar as we are concerned, it is not precedent. Is that not correct?
No, Your Honor.
Because the truth is that the provisions that they were interpreting may have had similarity in terms of the text that we find in our Constitution, but we have extra provisions in the 1987 Constitution. Is that not correct?
Yes, Your Honor.
That relates to your case. Is that not correct?
Yes, Your Honor.
For example,
Article 15, the right to found a family in accordance with their religious convictions, the nature or characteristic of marriage as an inviolable social institution that serves as a foundation of the family. And Article 2, Your Honor, in relation with the declaration that family life, the state should respect the sanctity of family life.
So are you claiming that, well, in that case that you mentioned in the United States, reading it casually, one of the debates between the majority and the minority, and that was a 5-4 decision, correct?
Yes, Your Honor.
One of the debates was whether it was correct to find an inchoate, invisible, substantive right to marry included within the provision that is similar to our due process clause. Was that not correct? In fact, the Chief Justice Roberts there, Alito, and several others were saying, while they may not disagree with same-sex marriage, it is for them something that must be statutorily constructed. Is that not true?
Yes, Your Honor.
Yes. So the debate there was whether, in fact, there was a right to marry as a fundamental constitutional right. Was that not correct?
Yes, Your Honor.
Yes. But they did not have Article 5, correct? Article 15 that we have now, correct?
Yes, Your Honor.
And in Article 15, Section 2, it says that marriage as an inviolable social institution is the foundation of a family and shall be protected by the state. Is that not correct?
Yes, Your Honor.
So, in essence, can you not say, or is it your position, that the right to marry is in the Philippines under the 1987 Constitution, not in the United States, not in Europe, but in the Philippines, that marriage is a right?
A constitutional right, yes, Your Honor.
Because it says the foundation of a family and shall be protected by the state. Is that not correct?
Yes, Your Honor.
Yes. So there is this right to marry that can be implied from Section 2. Is that not correct?
Yes, Your Honor.
Okay. And there is also a right to found a family, correct?
Yes, Your Honor.
Article 15, Section 3, the right of spouses to found a family. Is that not correct?
Yes, Your Honor.
Yes, and therefore to found a family requires, according to Section 2, marriage as an inviolable social institution, correct?
Yes, Your Honor.
Yes, so would you not say that the question as to whether or not there is an inherent, substantive, fundamental, constitutional right to marry is also already answered by Article 15?
Yes, Your Honor.
There is no other way to read Article 15 from your point of view.
Your Honor, we are guided by the decision in Antonio versus Reyes that it is a right and the legislature may...
No, but it did not handle the question of whether the right to marry is a constitutional right.
Yes, Your Honor.
As a
The
matter
case
of
of
fact,
Republic versus Manalo was...
You are correct that the first case that actually did so was Republic versus Manalo, correct?
Yes, Your
Where
Honor.
it was very clear in the ponencia that it is a fundamental constitutional right, correct?
Yes, Your Honor.
Or was it only a fundamental right?
A fundamental right, Your Honor.
So did it say constitutional? Of course, you quoted my separate opinion in your, as a quote in your pleading, but a separate opinion is always a separate opinion, carried only by a single justice who is always hopeful that in a future case it will be adopted. But of course, we are looking at the majority. In Republic versus Manalo, are you sure that the court purposely and consciously said that it was a fundamental constitutional right?
Your Honors, if I may quote, the case says, fundamental rights whose infringement leads to strict scrutiny are those basic liberties explicitly or implicitly guaranteed in the Constitution. It
Okay.
includes the right of procreation, the right to marry.
Okay, so the right to marry is there, already acknowledged, correct?
Yes, Your Honor.
Yes. Now, let us make a distinction between the concept of marriage, okay? One can only love through marriage. Is that true?
No, Your Honor.
So it's possible to love without marriage, correct?
Yes, Your Honor.
Yes. One can have sexual relations only through marriage.
No, Your Honor.
I mean, it's physically impossible to have sexual relations unless you are married. True or false?
False, Your
Yes.
Honor.
Is it illegal to have sexual relations outside marriage?
According to our public morality, Your Honor, no.
No, not public morality. I'm asking about legality.
According to...
I am not a priest. So
Yes, Your
therefore,
Honor.
my question is it illegal? So yes, it's illegal to have sex outside of marriage.
No, Your Honor.
Oh my
It is-
God, we have lots of criminals.
It is not illegal, Your Honor. I only mentioned public morality, Your Honor, to refer to secular.
That, by the way, was not an admission, but in any case, it was a question. Okay. In any case, so, is it illegal to have sex outside of marriage?
No, Your Honor.
Is it illegal to have a child outside of marriage?
No, Your Honor.
Is it illegal to have co-ownership outside of marriage?
No, Your Honor.
Is it, so therefore, it is possible to love, to promise, to commit, to found a family outside marriage.
To serve as a foundation of their family, Your Honor, no.
That was not my question. My question was, is it possible to love, to promise, to commit, to have children, to have intimate relations outside of marriage?
Yes, Your Honor.
Is it possible to have property relations outside of marriage?
Yes, Your Honor.
Yes. So what's the problem?
Your Honor, the family code...
Because your claim is, and if I may examine your arguments very carefully, that you are deprived of your right to intimacy, that you are deprived of your right to choice, that you are deprived of your right to have intimate sexual expression because of the prohibition that you cannot marry.
Your Honors, with the court's indulgence, the petition did not argue that without marriage, the LGBT people could not consummate intimate sexual relationships, Your Honor. We are only of the submission that without marriage, we lose access to a bundle of legal rights and obligations that will help serve as the foundation of their family, Your Honor.
So your claim is that marriage produces a legal status different from, well, let's unpack it a little bit more. Your claim is that marriage creates a social and cultural status, let's forget about the legal first, a social and cultural status which is not granted to the possibility of intimate relations among same-sex couples.
Yes, Your Honor.
Really? But if the couple is out, they can have friends that understand that they are together. Is that not correct?
Yes, Your Honor.
In fact,
Yes,
I know of a lot of same-sex relationships that outlasts married relationships among heterosexual couples.
Yes, Your Honor.
So it's possible. There is social recognition already, correct?
Yes, Your Honor.
And among the families of same-sex couples, if they are out and if there is acceptance, then there is also a recognition that there can be some relations that are created by two strangers when they pronounce themselves as being together. Is that not correct?
There can be a relationship, yes, Your Honor, but it is not a legal relationship.
A legal relationship, so it's illegal,
No, Your Honor, it is
So
just
it's
not
not-
recognized.
not recognized. What is this with recognition? What is it that is added by the legal recognition of marriage?
The legal recognition of same-sex relationships under marriage would allow them to access numerous rights and obligations, Your Honor, like the right to make decisions for their partner in the event of a medical accident where one person is in comatose. In the status quo, Your Honor, they cannot assert and demand by right to be in the hospital and make the decisions for their partner, or they cannot inherit, or they cannot claim SSS, GSIS benefits, Your Honor.
Let's look through that a little bit more. Is it not possible to delegate, to create a will, and in the will actually state that another person shall have arrangements or shall make the arrangements with respect to a decedent?
Yes, Your Honor. However,
In fact, the recent case of Balino versus Adriano said that, except that in that particular case, there was no will, and therefore it was granted to the legitimate spouse in accordance with the law.
yes, Your Honor, and not the mistress, Your Honor.
Okay, so it is possible by contractual relations for a couple in intimate relations to actually construct the kind of relationship that they want.
Yes, Your Honor. However,
So isn't this better than marriage?
for some people, Your Honor, yes.
Yes, I mean,
For some-
marriage, you are given a package deal. As a matter of fact, that marriage even has that provision that the only way that you can get out of marriage, or one of the ways, is this provision on Article 36, psychological incapacity. And according to this court, the dominant view is that Republic versus Molina still applies. And in same-sex couples, you can package a civil union. You can actually create the relationships amongst yourselves, getting bits and pieces from the law. Isn't that a more advantageous relationship?
With this court's
It has more freedom, it has more choices, and without the burdens of a married state.
With this court's indulgence, Your Honor, we submit that it depends on the person what kind of recognition or contractual relationship they want to have with the person. And some may want to have a relationship outside marriage and get expensive lawyers to create those contractual relationships. Some may want the right to marry, which comes as a
But I
package.
think we have to be careful about stereotyping. Not all lawyers are expensive. I mean, I'm looking at you. For example, you are a public interest lawyer, I suppose, doing a lot of work. I think you were also counsel for Spark, if I'm not, this curfew case, among others, decided by Justice Perlas Bernabe in a unanimous decision of this court. So we have to be careful because that will color emotionally the decisions in this case. There are available lawyers, even paralegals, that can help same-sex couples actually create a civil union. And that civil union can have all the rights provided by law, carefully constructed in order to be able to have, the best possible world. Isn't that more powerful, more liberating of one's agency?
Your Honor's petitioners are of the submission that not all legal rights may be
In other words,
appropriated.
even within the LGBTQ movement, there is a debate whether marriage equality is already gender equality, correct?
Yes, Your Honor.
That gender equality can be achieved even much more without marriage equality. There is some that take that kind of position. Is that not correct?
Yes, Your Honor.
Yes. So now, what is your argument now? So you can create your own relationship. You can have a civil union. Do not call it marriage. And you will not have, or you can create your own relationship with the in-laws or the other relations of the other party. Is that not correct?
Your Honors, petitioners may concede that there are some legal aspects we can access without marriage, with expensive or not expensive lawyers, but this would still put us in an unequal footing, Your Honors, as second-class citizens, because other couples do not need to go through those legal means to access
What I'm asking
the
you,
rights.
Attorney Falsis, is aren't people, heterosexual couples that go into marriage, more second class than what you can create?
No, Your Honors.
Because, it's a prepackaged set of law. In fact, if you trace that law, it comes from the Spanish Civil Code, okay? The partidas, and then the Nuevo Compilación, and coming from the Fuerzos Juegos before, correct?
Yes,
And
Your
it instilled the patriarchy. In fact, there's still some vestiges now of patriarchy in that particular civil code. And there are a lot of limitations. It is not culturally created. It's not endogenous within our systems. Can you imagine? Same-sex couples now can make their own civil union, correct?
Yes, Your Honor, in a limited
The
sense.
ideal of some legal scholars, which is to challenge even the constitutionality of marriage as a burden into their freedoms, is now available to same-sex couples.
Yes, Your Honor, but that is not by choice, Your Honors. The same-sex couples do not have the choice to opt out of marriage because
So,
they are not even allowed to opt
Is
in.
it accurate to say that you are arguing to get into a situation which is more limited.
Your Honors, there are some situations that would be limited under marriage, but there are other situations that are...
But you see, Attorney Falsis, that was not clear in your pleadings. And perhaps you can make that clear when you file your memoranda. What exactly in marriage, that status of marriage? So the status of marriage creates a bundle of rights and obligations. But the rights and obligations can also be fixed by contractual relations. Is that not correct? And because it can be fixed by contractual relations, you can actually create a little bit more perfect civil union. In fact, you can even say in your contract that we will stay together for 10 years. After 10 years, it's renewable. Correct? That cannot be done by heterosexual couples wanting to marry. But if that is your belief, then it can be established in that kind of an arrangement, correct? You may say not conjugal partnership or absolute community. You will specify the details of the co-ownership or the common ownership that you have of the properties that you have. You will say, everything that I make is mine, everything that you make, because you're richer, therefore will be shared by us. That's more egalitarian, correct? That's not in the civil code, right?
Yes,
And
Your
you
Honor.
can say that you can create property relations prior to committing to each other, and you can amend it after 2 years while inside the relations. Whereas in marriage, when is the only time that you can create the property relations?
In a prenuptial agreement, Your Honor.
Prenuptial. After you get married, you cannot change the property relations. Is that not correct?
Yes, Your Honor.
So, are you now saying that it is a limitation of your freedom rather than, do you agree with me that marriage limits the freedom of same-sex couples?
With this court's indulgence, Your Honor, there are contracts and stipulations that will not be allowed unless you are married because they will be contrary to law, such as the compulsory portion of one's inheritance or SSS and GSIS benefits, which can only go to a spouse, Your Honor, and the next of kin after that, Your
Let's
Honor.
follow that through. The legitim, correct? The compulsory portions of your inheritance, right? But if it's a same-sex couple, who should have that? And can you not provide in the will that the same amount that should be in a compulsory, the compulsory share of the spouse is now with your partner?
Your Honors, we don't think that would be allowed because if same-sex marriage is not recognized, the portion...
Who did you disinherit? The children?
Your
Your
Honors,
spouse?
in the simple understanding of counsel, Your Honors, there are two portions to a legitim, the free portion and the compulsory portion. While a person may freely give to anyone the free portion, the compulsory portion is given to a list of people by succession, and without...
Yes, the list of persons include legitimate spouse. But if the same-sex couple does not have a legitimate spouse, correct?
Yes,
There
Your
is
Honor.
no one.
It
Now,
will go
the
to
next
the-
one is descendants.
Yes, Your Honor.
And if the same-sex couples adopt singly or together, then there is that descendant, correct?
Your Honors, we don't think LGBT couples can jointly adopt under our present state.
So
of
that
law.
is one.
Yes, Your Honor.
So the solution there is to change the law on adoption,
No, Your Honor.
is to
because
change the law on marriage.
If by changing, Your Honor, it means going to Congress,
So why
we are not...
why
at that
is
submission.
changing the law on marriage more urgent rather than attacking other laws? I'm aware that there is an organ donation law that when a spouse dies, according to this law, that it is the legitimate spouse that decides whether the organs of the decedent can be donated. Okay? I'm
Yes,
aware
Your
of
Honor.
that. But that's a single provision which may be amended by Congress. And you know, in the process, Attorney Falsis, as you amend bits and pieces of other laws, you create an understanding of the nuances of gender identity, sexual orientation, gender and sex amongst our political leaders. who knows that at some point there can be legislation rather than relying on the Supreme Court to actually give you that right.
Your Honors, with this
And a
court's...
political acceptance by the majority is stronger than a decision of this court. We are unelected. We can be changed. We can be subject to quorum too, for that matter. And the Solgen is there looking at me very intently. So I am not sure what his intentions are. But the point there, Counsel, is that this is an unelected majority, unelected institution. Shouldn't it be stronger that culturally we get acceptance of things which are the vestiges of our heteronormative world and our patriarchy, so that it becomes stronger?
Your Honor, with this court's indulgence, while it may be desirable for the question of sex, sexuality, gender identity to pass through Congress, in the case of Philippine Blooming Mills, this court has said that fundamental rights are not subject to popular elections or to the will of Congress, Your Honor. Fundamental rights are and should be enjoyed by all.
Yes, but can you imagine the danger? This court can say that the right to contract, the right of contract is a fundamental right. And can you imagine what that will do in terms of social justice? If we are to be free in terms of dictating what is inside that concept of autonomy protected by the Due Process Clause, then as much as we can be liberal to progressive movements, we can also be liberal to non-progressive movements. Is that not
Yes,
correct?
Your Honor.
And you do not want the power to an institution that does not have political accountability. Is that not correct? There may be rallies that are conducted outside of our halls in Padre Faura. There may be newspaper articles that come out. There may be social media that attack each one of us, put us in memes, etc. But our sworn duty is not to be popular. Our sworn duty is to interpret the provision of the law. Is that not correct?
Yes, Your Honor.
Yes. So, what is it in marriage? Is there really inequality in terms of the interpretation of that status?
Yes, Your Honor. We are of the submission that the Family Code limited the definition of marriage by itself without due regard to the constitutional provisions about the right to marry in relation with the Equal Protection Clause and other provisions of the Constitution.
So you do not agree that for opposite-sex couples, when they choose the right of marriage, by the way, can opposite-sex couples, a man and a woman, or a woman and a man, may they opt not to marry?
Yes, Your Honor.
Yes. So the right to marry is really not a mandatory, compulsory duty.
Yes, Your Honor.
In other words, nobody can compel you to marry, right?
Yes, Your Honor.
Especially if we do not have a partner, correct? That would be the height of cruelty, right? Yes. So it is a privilege. It is an option, correct?
Yes, Your Honor.
And therefore, even opposite-sex couples or heterosexual couples may opt not to marry. Is that not correct?
Yes, Your Honor.
Yes. So my question is this. Why is there an insistence that same-sex couples can also marry, considering that there are many ways by which the civil union can also be reconstructed?
Our submission, Your Honor, is that heterosexual couples may or may not marry, but LGBT couples do not have the same choices to may marry or not marry, Your Honors. And as Filipinos, as taxpayers, as human beings with dignity, the Constitution requires that their rights be guaranteed as well.
Can same-sex couples have families?
Yes, Your Honor.
Can it be a loving family environment?
Yes, Your Honor.
Can it be a loving family environment without marriage?
Yes, Your Honor.
Can that family become an autonomous unit in our body politics such that it provides the foundation of a society because of its loving atmosphere?
Yes, Your Honor, subject to certain stigma or
Do you need
inequality.
a marriage certificate in order that that family contributes to society?
No, Your Honor.
So that family can be as strong as a family of heterosexual couples that get married. Is that not correct?
Your Honor, in their own private sphere, maybe in their houses, Your Honor, but when they go out and deal with the government or with state agents or instrumentalities, that relationship or loving family will not be given the same priority or rights or benefits, Your Honor.
Okay. Is marriage only for procreation?
No, Your Honor.
Is the compelling state interest in protecting marriage because it legitimizes procreation?
Your Honors, we are of the submission that procreation cannot be and is not the compelling state interest.
I am aware, of course, that the Catholic doctrine, if I am not mistaken, in my Catholic schools, is that marriage, one of the primary functions is procreation, but that's religion, correct?
Yes, Your Honor.
Yes, and you can marry at the age of 70, is that not correct? Is it a disqualification that senior citizens cannot get married?
No, Your Honor.
Overqualification?
No, Your
No,
Honor.
yeah. So senior citizens may get married, correct?
Yes, Your Honor.
But biologically, they cannot have an offspring, correct?
Yes.
So marriage is not for procreation simply, right?
As it stands now in our laws, yes, Your Honor.
What about the protection of tradition? Is that a compelling state interest?
Your Honors, petitioners are of the submission that that cannot be compelling state interest given that we are...
Would you agree with me that the law on marriage have changed through the years?
Yes, Your Honor.
Would you agree with me that there was a time that a married woman cannot contract without the consent of the husband?
Yes, Your Honor.
Would you agree with me that there was a time when we almost had a similar situation like coverture? In other words, the woman loses her identity. Is that
Yes,
not
Your Honor.
correct? And those change, correct?
Yes, Your Honor.
So if there is a compelling state interest to protect tradition, then we should not have changed our marriage laws.
Yes, Your
Correct?
Honor.
But is that applicable for the sexes of the couple?
Your Honors, we are of the submission that if even going by tradition, Your Honors, there were LGBT couples who were alive during the time that our Constitution was ratified and were already living together and had a loving relationship, Your Honor. Even in pre-colonial times, Your Honor, based on tradition, but because they were erased after
In
colonization.
fact, you have a concept of a babaylan, correct?
Yes, Your Honor.
What is a babaylan?
A babaylan, Your Honor, according to scholars, if I recall correctly, is a person who can access two sexes or genders, and sometimes they can perform rituals that heal people because of their different ability to access both sexes, Your Honor.
Okay. And the babaylan, therefore, can have a male partner, although she would be consider herself as with a sexual orientation wanting male partners, correct?
Yes, Your Honor. There is a scholar in the University of the Philippines by the name of Neil Garcia, and I obtained his permission to quote him that he has a paper that says there were babaylans that had male partners.
In view of the comment of the Solicitor General tracing the history of marriage, I would guess that in your memoranda, you would like to cover your own take of her story or history of marriage, correct?
Yes, Your Honor.
Yes, and I hope that it will be very clear that in certain instances, the history of marriage cannot only be the statutory provisions, because statutory provisions are impositions on cultures that are evolving, correct?
Yes, Your
Therefore,
Honor.
you might want to cover that in your memoranda. By the way, can same-sex couples procreate?
Technically, Your Honors, with the advent of
Yes,
science...
technically.
With the advent of science, with their DNAs together, they cannot, but individually with surrogacy or maybe an actual biological...
Yes, there are various
condition.
technologies that are available in order to be able to have an offspring where the DNA comes from either one, correct?
Yes, Your Honor.
By the way, these reproductive technologies, are they available to heterosexual couples?
Yes, Your Honor.
Yes, also available to them. And it is not because they have availed of that technology that the children are not their children. Is that not correct?
Yes, Your Honor.
They become their children only because they're married, correct?
Yes, Your
They
Honor.
become legitimate children because they are married, correct?
Yes, Your Honor.
Yes, but in such cases where, for example, one of the members of that heterosexual couple discovers that it wants to be more authentic with respect to its gender identity, or maybe not even gender identity, its sexual orientation, and therefore annuls or divorces the marriage. and chooses another partner, or that is more attuned with his authentic sexual orientation, then it is possible to make arrangements with that non-traditional arrangement, correct?
Yes, Your Honor.
Does that not destroy the family?
Your Honors, under our system of laws, it is only because there are absence of laws that recognize such situations that create that situation.
Broken families destroy family.
A broken family, Your Honor, yes, unfortunately, for some people, is a
In fact, when the husband and wife separates and not files for annulment, sometimes they become more cordial. Is that not correct?
sometimes, Your Honor.
And
Yes.
because they're more cordial, the atmosphere of the households, be they one or two, becomes more cordial for the children. Is that not correct?
Yes, Your Honor.
Yes. And they claim that a family with a male and a female, mother and father, is the only one that assures the protection of the family may not be accurate. Is that not correct?
Yes, Your Honor, it's not.
Because there can be non-traditional relationships where you have a second family but everybody gets together fine. Is that not correct?
Your Honors, when it
Does
comes...
the Constitution define family?
No, Your Honor.
It just says it's a strong autonomous political unit. Is that not correct?
Yes, Your Honor.
I'm sorry, social unit. Is that not correct?
Yes, Your Honor.
Yes, probably you can also cover that in your memoranda. You see, when a judge has a relation within the fourth degree of consanguinity and affinity, that judge has to recuse.
Yes, Your Honor.
That's in our implementing rules and regulations, the internal rules and regulations of the Supreme Court, correct?
Yes, Your Honor.
And that is also among judges. Is that not correct?
Yes, Your Honor.
So, in terms of judges who are sexually oriented towards the same sex, this will not apply, correct?
No, Your Honor.
They will not have to mandatorily inhibit because according to the law now, there is no consanguinity or affinity because they can never be legally married, correct?
Yes, Your Honor.
So
There's
there
no-
are these consequences of having a married state, correct?
Yes, Your Honor.
It may be more difficult, it may be more constraining, but it's the choice of the individual to choose such an arrangement. Is that not correct?
Yes, Your Honor.
Yes, okay. And in some cases where there are same-sex couples, the roles, cultural roles or legal roles of the in-laws, the cousins, may not be recognized, correct?
Yes, Your Honor.
Because one of the functions of marriage as a legal status is to actually bring the families of two strangers together. Is that not correct?
Yes, Your
And
Honor.
therefore, from there, create a larger clan, which will later on become bigger and bigger, which will be the foundation of our politics. Is that not correct?
Yes, Your Honor.
And by not allowing marriage to same-sex couples, therefore it disenfranchises their citizenship in that regard. Is that not correct?
Yes, Your Honor.
How come?
As citizens of this republic, Your Honor, they deserve the same rights and obligations or liabilities even as other citizens. And so, if on the one hand, there are situations that will not create those bonds that lead to either inhibitions or liabilities, then there is an inequality there, Your Honor.
Okay. Before I end, just to be clear, so that the terms are very clear. Sex and gender, what's the difference?
Your Honors, based on the most recent understandings of the community,
Sex is biological.
sex is
It
physical.
is
and
either
biological.
assigned at birth or it can be reassigned, correct? One
Unfortunately,
can
Your
go
Honors,
through a sexual reassignment surgery
Yes, Your Honor.
in order to be able to change one's biological sex, correct?
outside the law, yes, Your Honor, that is possible.
You mean it's illegal?
No, Your Honors.
In this country, it's illegal. Is it illegal to pierce one's ear?
No, Your Honor.
Is it illegal to do something with your body, like cut all of your hair?
No, Your Honors.
It's in fact fashionable, correct? Yes, but it's not illegal, therefore, as far as the revised penal code says, to actually go through a sexual reassignment surgery, correct?
It is,
The only thing that's illegal is suicide, correct? No, I'm sorry, not suicide, assisting suicide, because if it's suicide and the person dies, there is no accused already, correct?
Yes, Your Honor.
Yes.
Just to clarify, Your Honor, what I mean by it is not legal is that if one person changes their sex, except in the limited circumstance in Republic
That's the cultural, the legal aspect of it. I'm just clarifying the concept of sex, correct?
Yes, Your Honor.
Sex is different from gender, correct?
Yes, Your Honor.
Gender refers to the cultural, right?
It may either refer, Your Honors, to expression or identity.
So when one says gender identity, it means the kinds of roles that you associate with yourself, correct?
Yes, Your Honor.
Whether you are biologically male or biologically female, correct?
Yes, Your
The
Honor.
easiest way would be that if you are male and you choose pink, that doesn't necessarily mean that your gender identity is that of female, correct?
Yes, Your Honor.
It is just that you choose it, correct?
That would be gender expression, Your Honor.
Yes. So this is gender identity, how you consider yourself in relation to society, in relation to your choices, correct? That's gender identity.
Yes, Your Honor.
And gender identity can either be binary or non-binary. Is that not correct?
It can be either, yes, Your Honor.
So, which means that you can either be boy or girl, male or female. That's binary, correct?
Yes, Your Honor.
Or you can opt not to choose any. My gender identity is I'm asexual. My gender identity is, talk to me further, it's a conversational piece. Ask me questions and I will tell you my identity, correct?
Yes, Your
Yes,
Honor.
okay. Now, gender identity is different from gender expression, correct?
Yes, Your Honor.
Because you may have a gender identity which society says you should act in this particular manner, but in certain instances, you're a different person. You want to express yourself differently, correct?
Yes, Your Honor.
Like males that carry a muscled body that have earrings, that's gender expression, correct?
Yes, Your Honor.
Now, one way to express is your sexual orientation, correct?
Yes, Your Honor.
I'm simplifying it just so that it's clear. And therefore, sexual orientation is who you want to have intimate relations with, correct?
Yes, Your Honor.
So, gender identity is who you are.
Yes, Your Honor.
Gender, sexual orientation is who you want to go to bed with.
With the qualification, Your Honors, that sexual orientation is not a choice. It is something people just realize that they are attracted to a certain
Yes.
sex.
And to simplify things, the law has made it that every male will have all these kinds of gender identity and this sexual orientation. All females will have gender identity and sexual orientation, correct? That's how
Yes, Your Honor.
simplified the law is, correct? And now you are challenging that simplification by actually saying that there can be exceptions. There can be a constitutional and fundamental right with respect to same sexes, but their sexual orientation that they express is different, correct?
Yes, Your Honor.
Yes, because you are saying now that in the 1987 Constitution, when this was drafted, that was not yet a dominant view. That was not an accepted view, correct? In fact, right now, it may not be a majoritarian view. It may not be the dominant view, but people operate their lives in accordance with that, correct?
Yes, Your Honor.
Okay, is there a law which says all males should choose blue?
No, Your Honor.
Is there a law which says that homosexuality is a crime?
No, Your Honor.
Is there a law which says that having sex with the same sex is a crime?
No, Your Honor.
Whether it's male to male or female to female?
None, Your Honor.
There is none. And therefore, there is already some recognition that these things are not illegal and therefore people in the Philippines are free to live with that, correct?
Yes, Your Honor.
But there is a difficulty of outing themselves. In fact, as one of your petitioners in intervention, they opt to be anonymous for reasons which may be traced simply to an oppressive culture. Is that not correct?
Yes, Your Honor.
That there is no acceptance of who they are, correct?
Yes, Your
But
Honor.
what they should be allowed to do by a constitution that understands freedom is to have them accepted, correct?
Yes, Your Honor.
Because the Constitution celebrates not our respect for sameness, but celebrates our respect for otherness. Is that not correct?
Yes, Your Honor.
Okay, thank you.
Okay, good afternoon, Attorney Falsis.
Good afternoon, Your Honor.
Okay. Now, in your petition, you are challenging Articles 1 and 2, and in consequence, Articles 46, 4, and 55, 6, all of the Family Code.
Yes, Your Honor.
Correct. Now, you're also seeking to enjoin the civil registrar from enforcing the said provisions of the Family Code in processing applications for and in issuing marriage license against same-sex couples. Is that also correct?
With the qualification, Your Honors, that the prohibition is against the denial or processing for same-sex couples of licenses, Your Honors.
All right. Now, in paragraph 30 of your petition, you have mentioned that you have a personal stake in the outcome of the case and that you have suffered or sustained a direct injury.
Yes, Your Honor.
Now, what direct and actual injury have you sustained as a result of the Family Code provisions assailed in your petition?
Your Honors, we are of multiple submissions. The first would be that as an individual, I possess the right to marry because the right to marry is not given to couples alone. It is individual, Your Honors. Second, Your Honors, we are guided by this court's pronouncements in the case of Pimentel versus Aguirre that the mere enactment of a law suffices to give a person either an actual case or standing because, Your Honors, we are invoking the expanded power of judicial review where in the most recent cases, especially the one penned by Justice Bion, Association of Medical Workers versus GSS, this court said that under the expanded power of judicial review, that the mere enactment of a law, because Article 8, Your Honors, Section 1, says that any instrumentality, the grave abuse of discretion of any instrumentality may be questioned before the Supreme Court, Your Honor, and therefore the direct injury that I suffer, Your Honor, was the passage of a law that contradicts the Constitution in grave abuse of discretion because of the disregard of other fundamental provisions such as the Equal Protection Clause, the valuing of human dignity, the right to liberty, and the right to found a family, Your Honors.
But we have existing jurisprudence that says that if you challenge the constitutionality of a law or a statute, it is not enough that the law is invalid. There must also be a direct injury.
Your Honors, we are aware that there are cases to that effect. However, we are again guided by the most recent jurisprudence where this court itself explained that in many recent cases, mere enactments of law are sufficient to give rise to the invocation of the expanded power of judicial review, such as the Reproductive Health Law, the Anti-Cybercrime Act, the other cases, Your Honor, which escape my mind now. But there are cases of this court itself that has said that to that effect, Your Honors.
Have you actually tried applying for a marriage license?
No, Your Honors, because I would concede that I do not have a partner and that even if I do have a partner, it is not automatic that my partner might want to marry me. And so, Your Honors, I did not apply or I could not apply for a marriage license.
Now, what is the nature of a petition in intervention? Is that a separate action? Is that an ancillary to the main petition?
It depends, Your Honor, on how it was admitted by this honorable court. Petitions in intervention, when granted to join the main petition, are still separate and of their own existence, but read in conjunction with the main petition, especially, Your Honors, in this intervention, the interveners adopted the same arguments of petitioner, but added another argument, Your Honors.
Now, can the defects in the main petition be cured by the direct injury claim in the petition in intervention?
Your Honors, there are cases to that effect that when the petition in intervention is granted and there is actual case or standing in that petition, then the original petition is improved, Your Honor. The case has escaped my mind, Your Honor, right now.
And you know of any existing jurisprudence to that effect?
Again, Your Honors, it escapes.
And you can elaborate on that
We
in the
will elaborate
memorandum.
that in the memorandum, Your Honors.
All right, now let's go to the substantive issues. Now, Article 1 of the Family Code states that marriage is a special contract of permanent union between a man and a woman. Meanwhile, Article 2 states that no marriage shall be valid unless there is, among others, legal capacity of the contracting parties who must be a male and a female. Now, based on these provisions, the implication is that only marriages between a man and a woman are legally recognized. Is that correct?
Yes, Your Honor.
And only marriages that comply with these legal provisions are entitled to the benefits accorded by law.
Yes, Your Honor.
Now, Article 1 of the Family Code, in fact, makes it clear that marriage is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law.
Yes, Your Honor.
And therefore, the nature, consequences, and incidents of marriage are essentially legal in nature. Is that correct?
Yes, Your Honor.
So, is there any provision in the Family Code that prohibits same-sex couples from marrying each other?
Legally, Your Honors, it would be Articles 1 and 2, as evidenced by the denial of the marriage license applications of intervenors, Your Honor.
Now, are same-sex couples barred by the Family Code from exchanging vows in a marriage ceremony or publicly declaring their permanent commitment and union to each other?
No, Your Honors, when LGBT couples can and do marry in certain ceremonies, religious or otherwise.
So does the Family Code restrict same-sex couples from their ability to enter into committed relationships?
Yes, Your Honor, in terms of the legal aspect of marriage, Your Honors, because while intervenors, for example, may marry religiously under their own churches, that is only a religious ceremony, Your Honor, which will not give them legal access or access to legal benefits afforded to opposite-sex couples.
So effectively, the Family Code has not really prohibited same-sex couples from exercising these freedoms, except that the state does not recognize their marriage.
Yes, Your Honor, and we further submit that because of the non-recognition, that is the undue burden on the religious freedom of intervenors, Your Honor, because even though the Family Code does not prohibit them, by not recognizing their relationships like other couples, Your Honors, with their own religions, that it places an undue burden because it gives no legal recognition and security to their relationship.
So the only restriction that the Family Code makes is that it limits the recognition, legal recognition, to couples between a man and a woman.
It withholds the recognition, yes, Your Honor, legal recognition.
No, but does an individual have a fundamental right to choose who he or she can have a committed relationship with?
Yes, Your Honor.
Does that individual also have the fundamental right to express his or her commitment to that other person by marrying him or her?
In a religious manner?
Regardless of whether the marriage would be legally recognized.
Yes, Your Honor. They have individual human rights.
So does an individual have the fundamental right to engage in certain ceremonies following the customs and traditions practiced by his or her own religion?
Yes, Your Honor.
Now, is there a fundamental right to the legal recognition of marriage?
In relation, Your Honor, with Article 15, either secular or for couples who have religious convictions and want to found a family, yes, Your Honor.
So you believe that you can compel recognition on the basis of Article 15 of the Civil Code?
Your Honors, we would not frame it as a way of compelling recognition. We believe that there is recognition right now to other arrangements or relationships, such as heterosexual couples. The compulsion comes from the Constitution because of the Equal Protection Clause, Your Honors.
So is there really a distinction between a right to marry as a cognate of the right to life and liberty, and even an aspect of freedom of expression and religion, from the concept of legal recognition of marriage?
There are distinctions, Your Honor, but we submit that the concepts are intertwined because when individuals have a right to choose who they want to live their lives with in relation with free expression and religious freedom, while marriage is separate, it is intertwined because some aspects of expression and religious freedom are enhanced or diminished by marriage recognized if it is recognized or not, Your Honors.
Now, can you invoke the Bill of Rights of our Constitution as a source of entitlement to benefits or a mere freedom from government intrusion?
Your Honors, when it comes to marriage, which is a bundle of legal rights and obligations, we are guided by the case of Antonio versus Reyes that while it is the province of the legislature to set the parameters, it is still subject, Your Honors, to the Constitution and the court said differently, and the Bill of Rights, Your Honors.
Now, does the Constitution define marriage?
No, Your Honor.
Does it define who are qualified or allowed to marry and those who are not?
The Constitution, Your Honor, characterizes some nature of marriage, which is that it is an inviolable social institution and serves as a foundation of the family, but the rest, Your Honors, are not.
Now, when our Constitution was drafted, was it presumed by the framers that marriage follows its historical and traditional concept, that it is a union between a man and a woman?
Your Honors, we are aware that there are two commissioners in the constitutional deliberations that were of the idea that marriage, as written in Article 15, is to mean between a man and a woman. We are aware, the petitioners are aware of that, Your Honors. However, it is our submission that the intent or idea of two framers, Your Honor, does not reflect the intent of the rest, but further, Your Honor, with this court's indulgence.
So
We would like to mention the fact that one of the framers of the 1987 Constitution, Director Lino Broca, was openly gay, Your Honors, and that during 1987, when the Constitution was ratified, LGBT couples have been living together and have existed, but unlike intervenors, they do not have the openness to come out and be subjected to scrutiny, but a lot of old LGBT couples are still alive today, Your Honors, and they were alive during the 1987.
So you do not think that the right to marry protected by the Constitution should be understood as merely between a man and a woman?
No, Your Honor. We are guided by this court's pronouncements that intentions of the framers must be reflected in the text of the Constitution. If there was such intent and the framers discuss it, but they did not codify it into the text, we are of the opinion that this court can use the principle of casus omissus, Your Honor, where if it wasn't written there, if it was omitted, then that intent does not control. And so we are of the humble submission, Your Honors, that marriage, while it does include man and a woman, because the framers and two framers contemplated it to be that way, is not limited to only a man and a woman, Your Honors.
But you would agree that that was the framers' understanding?
The two framers, Your Honors, because they were on record. Unfortunately, the record was very sparse. It was only a one-page deliberation, Your Honor, of two commissioners or framers, and the other framers were not involved in the discussion, Your Honor.
Now, can this understanding be overturned by the court through an analysis of new insights and norms subscribed to by our society today?
Your Honors, we are guided by this court's pronouncements that the first step this court does is to look at the text of the Constitution, and before interpreting or trying to, if this court could overturn the intent of the framers, will not look at the intent of the framers if the text of the Constitution is clear under the principle of verba legis. We believe that the text of the Constitution is clear that it is not limited to a man and a woman. And we submit further, Your Honors, that we must use the principle of ut mahis valeat quam pereat, and that means, Your Honor, I'm sure Your Honors know this, but it is to harmonize the provisions of the Constitution. And so Article 15 must be read in conjunction with Article 3, Section 1, and Article 2 in relation with the valuation, the state valuing human dignity, Your Honor.
Don't you think this is a political question that should be left to the discretion of Congress?
We are of the opinion, like the question by Justice Leonen, that while it may be desirable for Congress to be the one to enact a law allowing same-sex marriage, Your Honors, our submission is that first, fundamental rights cannot be subjected to the political wins or to popular elections, Your Honor. And we are guided by the pronouncement in Angladlad versus Comelec or in other more recent cases that this court does not make decisions based on popularity. It makes decisions based on fundamental rights, and if the tests under the Constitution are passed or failed by the statute or law questioned, Your Honor.
Now, the Constitution provides that no person shall be denied the equal protection of the laws.
Yes, Your Honor.
However, the Equal Protection Clause does not require the universal applications of the laws, and the legislature is allowed to classify the subjects of legislation. Now, can you give me the requisites for a valid classification?
A valid classification, Your Honors, must be one, that the legislative classification rests on substantial distinction. Second, Your Honors, that the classification must be germane to the purpose of the law. Third, that the classification is not limited to existing conditions. And fourth, that the classification is applied equally to all members of the same class.
Now, is there a substantial distinction between the same-sex and opposite couples insofar as granting legal recognition to their marriages?
We submit, Your Honor, that there is no substantial distinction, while there might be a common perceived distinction by common layman Filipinos that LGBT people cannot ordinarily procreate. We are of the submission that this is not the distinction that the family code itself looks for. If the purpose of marriage is for the establishment of a conjugal and family life, in Article 68 to 70 of the family code lists out the essential marital obligations, that there are no substantial distinctions in how LGBT couples or same-sex couples can fulfill the purposes of marriage and the essential marital obligations, Your Honor.
Isn't the ability to procreate a substantial distinction because it mirrors society's traditional and natural concept of a family, which the state has the right or interest, reasonable interest to foster?
Your Honors, we are guided by this Court's pronouncements in the cases of Republic versus Albios and other cases where state interference in terms of whether the state can tell couples to have children or not would raise serious constitutional questions, and that is why the family code does not require couples to procreate or have children to be able to access marriage. And therefore, Your Honors, while there might be a cultural perception or tradition that marriage is for procreation, we do respect that from petitioners, Your Honor, but others are also of the belief, even straight couples, that they do not need to procreate or have children to be able to enjoy the benefits of marriage. And we have straight couples, Your Honors, that do not have children and yet are married.
Now, but while couples are not obliged to procreate, it's the mere ability to create that justifies a distinction. Do you agree with that?
Your Honors, with this Court's indulgence, we do not agree with it because this Court also explained in other cases that impotency is the only ground under the family code and not sterility. And therefore, Your Honors, the ability to procreate is not a core or central focus of the family code. It might be a focus, Your Honors, of some people, of some religions, and they are allowed, Your Honors, to follow what they believe. But what about, Your Honors, interveners who are also Christians, but do not and may not share the same belief, Your Honors?
Right, do you think it's about time to correct the inequality in the institution of marriage?
Yes, Your Honor, it is about time to correct the inequality. And the correction, if we may further add, Your Honor, can come from this honorable court because of the rules we have about fundamental rights.
Notwithstanding that the function of the court is only to interpret the laws and not to correct such inequality?
In the course of interpreting our laws, Your Honor, this court in past cases, as a consequence of interpreting the law, have corrected certain inequalities. So, Your Honors, the petitioners are not asking this court to primarily correct the inequalities, but interpret the Constitution because the Constitution, Your Honors, itself mandates equal protection.
All right, thank you very much, Attorney.
Thank you, Your Honors.
Justice De Castro.
there is an agreement that marriage between a man and a woman is not mentioned in the Constitution, and that the Constitution also does not require that family is founded on the marriage between a man and a woman. Now, what do you say about the provision of the Constitution that the Constitution shall ensure the fundamental equality before the law of women and men? It does not speak of gender equality. What is your view about this provision of the Constitution in relation to the discussions?
Your Honors, we are aware that our system of laws so far do not conceive or have not conceived the spectrum of sex, sexuality, and gender identity, and even that the Constitution follows a binary model, which is a man and a woman. However, Your Honor, our petition still works within that framework because by extending the right to marry to same-sex couples under our birth certificates or even under our legal system, all people or all Filipinos are still either man or woman, but they are not prohibited from following or expressing their gender, but they are discriminated when it comes to marrying the same sex. And so, Your Honors, the equality between men and women there still help and allow our petition to operate within that framework.
So, are you saying that still there is the biological difference between a man and a woman, but you're advocating same-sex marriage because of the sexual orientation of the parties?
Yes, Your Honor. There are instances that petitioners concede that biological distinctions will be crucial or will be germane to the purpose of the law, such as violence against women and their children, or maybe maternity leaves, Your Honor. But in relation with the purposes of marriage, that the distinction between sexes is not material and therefore there's no substantial distinction.
Can you cite any legal basis, whether domestic law or international law, where gender equality is assured as a fundamental right?
Your Honors, in the European Union and in the International Covenant for Civil and Political Rights, not only sex is protected or mentioned, but also sexuality, gender identity, and or gender expression, Your Honor. While the ICCPR might not be that clear, Your Honors, the interpretation of the United Nations has been to that effect. But the European Union is more clear to that effect, Your Honors.
What about any international covenant or instrument where the Philippines is a party which recognizes gender equality?
Your Honors, if I recall, there are international instruments focusing on women, which uses the word gender equality, but the name of that treaty escapes me now, Your Honor, that we are a party to, and is mentioned in the Magna Carta for Women.
The sexual orientation, the gender, I'm referring to gender equality, not the grant of the rights of a woman to make a woman equal to men. So I'm referring to gender equality as guaranteed by international convention to which the Philippines is a party.
Your Honors, Council is currently unable to mention international instrument which mentions gender equality or sexual orientation that the Philippines is a state party to. We will address that in the memorandum, and if there are none, Your Honors, we will not use any international instruments, Your Honor.
Okay, please do that because the Constitution does not refer to gender equality insofar as sexual orientation is concerned. As it was mentioned earlier, this is a new concept, the LGBT
Your Honor, if with this court's indulgence, we would like to refer this honorable court to the case of Angladlad versus Comelec. While there, the Yogyakarta principles were correctly deemed not to be a binding international law on us, this court found that sexual orientation, while not mentioned by the Constitution as a party list that could run, or a party list that advocates for the protection of people who have different sexual orientation or gender identity, that this court found that in relation with the Constitution, there is a right for people with that sexual orientation or gender identity to form a party list, Your Honor. So this is not totally new for this court, Your Honor.
Do you agree with me when I say that there is nothing constitutionally infirm in the provision of the Family Code which recognizes the validity of a marriage between a man and a woman?
Yes, Your Honor, there is nothing constitutionally infirm.
So there is no need to nullify that provision of the Family Code. If ever there is only a gap, there is a gap in the law, a gap which can be supplied by Congress.
Your Honors, it is our submission that the gap need not be supplied by Congress, and that to qualify our position again and to clarify to this court that it is not our position for the nullity of Articles 1 and 2, which would lead to straight couples not being able to marry. Our position, Your Honor, is that because as it stands now, it would lead to nullity, that this court, under the expanded power of judicial review, can be, and in relation with the pronouncement of constitutional supremacy, that the Constitution is deemed written into every statute, that the phrases man and woman will now also include a man and a man or a woman and a woman, because that statutory provision is juxtaposed with the Equal Protection Clause, Your Honors.
Now, if that is done, what will happen to the application or enforcement of provisions of numerous law pertaining to the relationship of a man and a woman who enter into marriage or matrimony?
Your Honors,
What will happen? For instance, let me ask you this question. How will you now apply the provision of the Penal Code on concubinage and adultery in case there was infidelity on the part of one of the parties to the same-sex marriage?
Your Honors,
Will there be no need to define how this provision of the Penal Code will be applied in case of same-sex marriage?
Your Honors, our submission as to the specific question of how the articles in the revised penal code on concubinage and adultery will operate is that it will still be sex-specific, Your Honor, but we would like to highlight the fact that there are bisexuals in our community. And so some of them, Your Honor, actually might fall under that provision, given that not only when a same-sex couple marries, Your Honor, one of them could actually be bisexual and therefore could commit the crime of concubinage or adultery. And further, Your Honor, this might be the question in the minds of the court as to the other sex-specific provisions of law, like the tender age presumption and maybe the 180-day period, Your Honor, when it comes to a spouse who has a deceased spouse. Our submission, Your Honor, is that there are very limited instances that there are sex-specific provisions. We implore this court to first look at the numerous provisions that do not need to apply sex-specific or to sexual orientation-specific, Your Honor. And in relation with the sex-specific provisions, that those will still stand and be made to apply in cases where they are applicable, Your Honor. So for example, if there is a lesbian couple, 2 women, then the tender age presumption may still apply, Your Honor, if the child was the biological child of one of the partners, or it may not apply if they just adopted a child, Your Honor. But
We're referring only to, as an example, the crime of concubinage or adultery. Now, if there are 2 women who enter into marriage, and one commits a sexual offense penalized by the penal code, what will you apply? Is it concubinage or the elements of concubinage or the elements of adultery? Or are you saying that since they are both women, then you apply the provisions on adultery? If they are both men, you apply the provision of concubinage? Is that how it will be done? The point that I'm raising is that if we just simply say that we should allow the marriage between persons of the same sex, there are so many provisions scattered in our law books which will require interpretation. And this can only be done if there is a comprehensive law enacted by Congress that will address each of these issues. Like for instance, the ground for legal separation. Of course, if we allow marriage between persons of the same sex, are we going to apply the grounds for legal separation? Are we going to apply the grounds for the annulment of marriage? What about their personal relationship? There are so many aspects in the relationship between couples, whether they are of the same sex or they are heterosexual, that will require the implementation of our laws. And so it may be difficult for the court to simply say, let us allow same-sex marriages without defining the relationship, the numerous relationship that may arise because of the marriage between two persons of the same sex, which under our laws apply to a marriage between a man and a woman.
Your Honors, we sincerely see the difficulties that may be encountered if this petition is granted. However, Your Honors, our first submission is that when it comes to fundamental rights, when there are other issues that the court must face, the court focuses first on the fundamental right and whether the denial or deprivation is proper, regardless of other consequences that might flow from upholding that fundamental right. But second, Your Honor, to answer the specific question again on concubinage and adultery, the humble submission of counsel, Your Honor, is that it depends on who the same-sex person cheats with, Your Honor, because the crime of concubinage and adultery is committed with another person. And we would like to emphasize, Your Honor, that when it comes to the revised penal code, same-sex couples and opposite-sex couples are still equal, if ever, Your Honors, when it comes to bigamy. Now, however, Your Honor, our last submission is in relation with the provisions on homosexuality and lesbianism, that the petition itself, Your Honor, has requested that if this court agrees that Articles 1 and 2 are unconstitutional and will now allow same-sex couples to marry, that homosexuality or lesbianism cannot be used as a ground to legally separate, because now that would be absurd when same-sex couples can marry and yet use their own sexual orientation as a ground for legal separation or annulment, Your Honor.
If we do that, there will be a lot of confusion that may arise when the legal relationship between parties to the same-sex marriage arise in the course of the marriage. And there are so many of them. And if they come to court and there's no law to guide the judges, how will the judges decide specific cases brought before their courts involving the relationship between parties to the same-sex marriage if we do not have a law that will define each of the possible issues that may arise with respect to their property relation, with respect to their right to choose their home, with respect to their right to purchase property, with respect to their right to adopt children and raise them as parents of adopted children. There are so many aspects of the relationship of persons of the same sex that enter into a marriage that needs to be defined by law.
Your Honors, our first submission in relation with the difficulty presented, if ever, Your Honor, is that the Civil Code itself states that difficulties or gray areas in the law, Your Honors, is not a reason for courts to not make a decision, Your Honor. And we are of the second submission that there is a law that could and would guide judges and justices, Your Honor, and that is the Constitution, Your Honor. Even under the Family Code, when there is a dispute between a man and a woman, the recourse is still to go to the court and let the judge decide based on legal and other consideration, legal arguments and other considerations, what will be the result of an issue, Your Honor.
What is your opinion about an alternative to marriage, which is a civil union that may also be provided for by law? Civil union, it's defining the relationship between parties to a marriage insofar as their property relation is concerned or other civil rights are concerned. So it's different from marriage as we understand it now.
Yes, Your
It's
Honor.
similar to the arrangement mentioned by Justice Leonen, where there is a package of agreement between the two parties, which may be provided for by law. Instead of them entering into an agreement, separate agreement, the law will define the relationship in a civil union that is recognized by law, passed by Congress.
Yes, Your Honor, we are aware that there are pending bills in Congress creating the concept of a civil union. However, even the proponents, Your Honor, mostly mention that this is similar to marriage, but they just want to call it as civil unions. The position of petitioners, Your Honor, is that if civil unions are essentially the same in terms of granting legal rights and obligations as marriage, that there will now be joint property relations, that there will be a degree of consanguinity or affinity, that there will be liabilities and obligations between two people. If it is essentially the same, Your Honor.
The right to inherit, the right to acquire property,
Yes,
to
Your
enter
Honor.
into contracts.
Our position would be, if it is essentially the same, our position is that the Equal Protection Clause cannot sanction that, Your Honor, because we refer this court to the situation in other jurisdictions, while not controlling, but is persuasive. During the segregation era, Your Honor, blacks were told that they can go to schools, but they were only allowed to go to black schools and not allowed to have desegregated schools, Your Honor. That would be separate but equal. For LGBT people, it would be called civil unions. But essentially, the content is the same with marriage. We are of the position, Your Honors, and we submit that marriage might be a religious term for a lot of people, but it is also a legal term, and that is the only term, or that is the only area we are trying to argue before this honorable court, that we be given the same term, the same name, because we are also Filipinos, we are also taxpayers, and to have civil unions, Your Honor, again, with the same content as marriage right now, would be to make us second-class citizens because the state called it by a different name.
Just a matter of nomenclature.
Your Honors, petitioners would like to highlight that the issue of denomination or how a concept or a right is called goes into the heart of the Constitution when, Your Honors, I would like to mention the preamble where we have a regime of love in relation, Your Honors, with Article 2, that the state values human dignity. The denomination or the name matters, Your Honor, because this is the message that the state sends or creates if basically two concepts are the same, the content is the same, but the state calls it by different name, that means, Your Honor, that the two groups are not the same, but they are given the same content. The Constitution would ask, why would that be the case, Your Honor?
Will you put in your, if ever you're asked to submit a memorandum, will you put there the reason why you do not want to call the relationship between same-sex couples as a civil union instead of marriage?
Yes, Your Honor.
Will you cite the difference between the two and why you object to the use of the term civil union instead of the term marriage?
Yes, Your
And
Honor. For now, Your Honor, may I, with this court's indulgence, also refer this court to the situation in other jurisdictions where civil unions have been outmoded because precisely of the fact that if it is really the same in content with marriage, that giving civil unions to LGBT couples while giving the term marriage to opposite-sex couples would still be discrimination, Your Honor. And we would put that in the memorandum, Your Honor.
probably the reason why there is an aversion to the use of the term marriage is because of religious values and beliefs.
We recognize that, Your Honor.
You can include that in your memorandum so that we will get a complete picture and also an explanation as to how the issues I raised about the implementation of the numerous provisions of the law, our laws on marriage can be applied and to this same-sex marriage that you are advocating.
Yes, Your Honor.
I have no further questions.
Thank you, Justice Bersamin.
Thank you, Chief. Were you the one assigned to argue the procedural issues or the other counsel?
The Attorney Darwin Angeles, Your Honor, was the one who argued the procedural issues.
Yeah, I will give you a short rest. May I have the co-counsel come forward? The name is Attorney Angeles.
Yes, Your Honor.
Okay, Attorney Angeles, I did not hear any argument from your side regarding the procedural viability of the petition. But anyway, since you have been given that assignment, let me focus on these issues. I have chosen to file a certiorari and prohibition petition.
Yes, Your Honor.
And yet the only respondent that you named is the civil registrar. Were you privy to the preparation of this pleading?
Myself, Your Honor, no, but we... yes, Your Honor.
Will you be competent to answer my questions? You have to be from the time of creation, to be present at the time of creation if you were to answer my questions. Will you? Or may I ask back the petitioner himself? Herself or himself? Himself.
I can answer the...
All right, may I have back Tony Pausis? I'm sorry to cut short your rest.
No problem, Your Honor.
Attorney Pausis, when you decided to file this petition, did you yourself do it personally or did you have advice from experienced litigators in the Supreme Court?
Your Honor, I did it personally, but with consultation and advice of some professors or people I trusted to give me good advice, Your Honor.
Okay, I'll grant you that privilege. But you see, certiorari and prohibition are the only vehicles probably that you will have in order to invoke the power of judicial review of the court. You have been very frequent in mentioning that you have asked the court to exercise the power of judicial review. But yet the only respondent that you have included or impleaded is the civil registrar. Is he a department or is that an office that is a branch of the Philippine Republic, or is that a minor official?
Your Honors, we are of the submission that the reason why it was the Civil Registrar General that was impleaded was because it is the instrumentality of the government that is tasked to enforce the law in relation with marriage. And following this court's precedents, Your Honor, such as Magallona versus Executive Secretary, until Your Honors, Imbong versus Ochoa.
All right,
that-
I understand, because I seem to have heard you a lot about your capacity and facility to cite cases or precedents set by the court. But the trouble here is this. The civil registrar did not even do you any injury because you did not even try to apply for a marriage license there. So, you still implemented him or her or whoever is that official.
Yes, Your Honor, we believe that it is proper to implead the Civil Registrar General because when it comes to Rule 65 petitions, Your Honor, in the way that petitioners invoke it is in the expanded sense.
Yeah, I understand. Now, the expanded jurisdiction under the second paragraph of Section 1 of Article 8 refers to abuse of discretion.
Yes, Your Honor.
The civil registrar has no discretion. It has only a ministerial duty to issue you a license or to deny you that license. So, could you not have resorted to mandamus in the regional trial court of where you have a refusal? You should have done that.
Your Honor, with this court's indulgence, we are of the submission that in other laws that were questioned, the constitutionality of other laws that were questioned.
No, you cannot make your case similar to those other laws because those other laws were against other branches of government. They were seeking genuine judicial review. Here you are asking us to perform a very ordinary task of correcting somebody's mistake which was not even a mistake. Because there was no instance where you asked that official to function as such.
Your Honors, with all due respect, similar to the case of Decini and other petitioners against the Anti-Cybercrime Act, the Secretary of Justice also did not do anything yet, Your Honors, but it was the SOJ that was impleaded because along with other government officials, he or she was the one tasked.
All right, the whole point of these questions, Attorney Pausis, pardon me for interrupting you so often because we do not have the luxury of time. What we need here, when you come to us, is an adverse party. All right? Because we are not allowed as a court to render advisory judgments or opinions. What we need is an actual case and controversy. And that requires an adverse party. And yet you say, nothing has been denied to you by the respondent. So where would this adverseness come from? You will be asking us to rule on a hypothetical situation. And that cannot be allowed. Don't you realize that, or did you not learn that from law school or from your readings?
Your Honors, petitioner is aware that he is not as experienced as most other lawyers.
Well, anyway, never mind. We can understand that you are not experienced. Now, let me go to this other matter that has been bothering me. Why did you come to the court directly? There is a danger, according to Justice Lonen, that you might be losing a very interesting case for the rest of the LGBT community because of this aggressive coming to the court without a careful preparation.
Your Honors, when I was preparing the petition, I was guided by recent cases where there were exceptions to the doctrine of hierarchy of courts, and that this case falls under numerous exceptions, Your Honor. And that is why a direct resort to this honorable court is proper because it involves fundamental rights that are novel when it comes.
You see, even if I have fundamental rights, they have fundamental rights, but if those rights are not violated, there is no occasion for the court to go to your help, succor, or to your assistance. Don't you understand that? You need to allege to us a an injury or an interest that is deprived of you or that is affected negatively. But yet, you just admitted to Justice Bernabe a while ago that you did not even file an application for license that was denied. So how come you are now putting to task this official, minor official at that? And yet you want the court to act through its power of judicial review. You may have a very strong argument, but you have no case. That's my point.
Your Honors, we submit that the adverseness this court is looking for comes from the fact that when any instrumentality of government is questioned under Article 8, Section 1, in relation with Rule 65, Your Honor, that the Solicitor General represents those instrumentalities.
All right. Rule 65 is certiorari and prohibition. They rest on abuse of this grave abuse of discretion amounting to lack of jurisdiction or excess of jurisdiction.
Yes, Your Honor.
But if you did not have this civil registrar act one way or the other, how could there have been grave abuse of discretion or abuse of discretion?
Your Honors, the grave abuse of discretion here relates to the actor that passed the family code. And Your Honors, I know that there are many decisions.
All right, if that is your answer, why did you not include the Congress of the Philippines?
Your Honors, it is not Congress that has been the precedent when it comes to impleading parties who are involved in the implementation of the law. We refer again, Your Honors, this court to the cases of Dicini and Imbong and other cases after that, Your Honor, where it was not Congress that was impleaded but the government officials who were tasked to implement the law.
Maybe for my education in particular, if you were ever to be required to file a memorandum after these oral arguments, will you please expand on this, because I really want to help if I could, but not if you are merely seeking an advisory or hypothetical decision from the court, which we cannot
Your Honor,
do
we will
for you.
address it in the memorandum, but for Your Honor's satisfaction for now, Your Honor, I would like to emphasize that as a Filipino and as a lawyer, I would like to stay in this country and die in this country. And so, Your Honor, while it may seem that I need to have a partner and I need to have filed a marriage application license, Your Honor, it is our submission that the right to marry is individual in nature, where it allows other people to may or may not marry, Your Honors. And that is the injury that I suffer, Your Honors, that as a Filipino, I do not have, because I am attracted to the same sex, and I openly admit that, Your Honor, that I do not have the right to may or may not marry as other people situated in the Philippines.
So why don't you apply first for a marriage license before you come again to the court?
Your Honors, petitioner admits that he does not have a partner, but again, Your Honor, with this court's indulgence, that was not needed for...
No one will force you to do anything, but please remember again the requirements next time you come to the court. Because the court, this is a very good question, but it is not the kind of question we would like to settle for you at this time, as far as I am concerned. Thank you very much.
We submit, Your Honor.
Justice Ardilesa.
Counsel, may I be permitted to ask some questions from Petitioner Agbayani?
Yes, Your Honor.
Chief, can...
Yes, Mr. Agbayani, can you please approach the podium?
Good afternoon, Your Honor.
Good afternoon, Petitioner Agbayani, and how do I address you, sir?
CJ na lang po, ang nickname ko po.
CJ, Reverend CJ?
Yes po.
Yes. Now, Reverend CJ, I have here, and I wonder if you will remember, on June 27, 2011, so this is quite many years ago, you were interviewed by a reporter of GMA News by the name of Candice Montenegro. Would you remember that?
Hindi po masyado. Pero
Hindi masyado. But to help you remember, it says, among others, that the Metropolitan Community Church, MCC, a Protestant church in Quezon City, Makati, and Baguio, said it has been celebrating weddings between same-sex couples since the 1960s.
yes po.
Yes.
Yes po.
And in fact, it says here, and I quote, the first same-sex wedding was between two lesbians in 1969,
Yes.
said Agbayani.
Yes, Your Honor.
You remember that?
Opo.
Now,
Yes, Your Honor.
and then the petition for intervention says that the LGBTS Christian Church, Inc. was incorporated in 2012.
Yes, Your Honor.
So, can you explain, were you already a reverend or a pastor of the MCC?
Yes, Your Honor. I was the founding pastor of the Metropolitan Community Church of Quezon City in 2006. Well, actually, as a Bible study group, and eventually affiliated to Metropolitan Community Church, and eventually become Metropolitan Community Church of Quezon City in 2007. And then we become an independent church in 2012. And we rename our church into LGBTS Christian Church. Although there is still MCC in the Philippines, but I founded a church named the LGBTS Christian Church in 2012, Your Honors.
So, you founded a church in 2012.
Yes, sir.
So you call LGBTS Christian Church, Inc.
Yes, po.
a church.
Yes po. Yung S po doon sa LGBTS is not a plural term, but it stands for straight. May mga straight member din po kami. Iba po straight lang ang kilay, pero straight
Now,
lang din po.
can you tell us what is the difference of LGBTS Christian Church as a church from Metropolitan Community Church?
Actually, I'm inspired to found a church based on my inspiration to the Reverend Troy Perry, the founder of Metropolitan Community Church in 1968. He was the founder of Metropolitan Community Church. And with that inspiration, and with my studies at Union Theological Seminary, I finished Master of Divinity po. And the focus of my ministry is to the LGBT people. We decided to have a safe space for LGBT, and we call it the LGBTS Christian Church. Because yung idea po kasi is the fusion of being an LGBT and Christian. For the longest time kasi po, lagi po natin sinasabi na hindi pwedeng pagsamahin ang pagiging bakla at pagiging Kristiyano. In this case, with my experience, personal experience, with my personal God, pwede ka palang maging bakla at Kristiyano. So, tapos pinopromote din po namin yung word na LGBT kasi hindi yung karamihan po ang alam lang po sa bakla tomboy, yung gano'n.
Ngayon, sinabi mo na meron kang hinahangaan.
Yes po.
Na reverend ba doon
Yes,
sa
po.
MMC?
Yung founder po ng Metropolitan, si Reverend Troy Perry, siya po yung founder ng
Pakiulit po, Reverend.
Reverend Troy Perry.
Kung hinahangaan mo si Reverend Troy Perez,
Perry po.
Perry,
Apo.
bakit ka pa pumalag? Bakit ka pa nagtayo ng sarili mong simbahan?
Nagkaroon po ng internal issue po sa loob ng simbahan. Lahat naman po ng simbahan ay may politika. So, nagkaroon po ng maliit na politika sa loob ng simbahan. Kaya po we decided na
Yun po bang politika ay politika sa pananampalataya o personal? Hindi
personal po.
personal. So, pupunta ako sa paniniwala ng
MCC po.
MCC sa same-sex marriage. Yan ay paniwala ng MCC.
In 1969 po sila po ay publicly nagkaroon ng yes po, kasi we want an inclusive church. Sa Metropolitan Community Church po, although we are all LGBT, but we are all inclusive church and affirming po. Pag sinabi po kasing affirming, hindi problema sa simbahan kung ikaw ay LGBT or not. Basta affirming ka. Ina-affirm niya po.
Dahan-dahan lang po para kasi may stenographer.
Ipagpabanin po.
Maulit lang po. Yung sinasabi niyong MCC, ang paniwala ay same-sex marriage o hindi lahat ng MCC ay naniniwala?
Lahat po ng advocate po ang Metropolitan Community Church ng marriage equality, maging sa Estados Unidos po at saka maging dito sa Pilipinas.
At nasaan nakasaad yun ba ay doktrina ng simbahan na MCC?
Hindi naman po nakalagay sa doktrina itself na katulad na dinideclare. We advocate po for marriage equality as para po ministry po ba. Ang katulad po
Dahan-dahan. Pero may doktrina kayo. Ang doktrina ay iba sa paniwala or affirmation about marriage. May doktrina ang MCC. Anong doktrina ng MCC?
Ang doktrina po ng simbahan ng MCC ay doktrina ng pagmamahal po. Yung acceptance, yung acceptance, yung love, the doctrine of love. So, the doctrine of love will include the heterosexual and LGBT rin po. So,
Now, pupunta ako ngayon sa yung simbahan mo ngayon, yung LGBT Church. Yun ay is there a different doctrine with respect to same-sex marriage? Is that found in your whatever you call it as a doctrine?
hindi po naman sa doktrina, pero meron po akong theology or pag-aaral patungkol dun sa kung ano po ba yung biblical basis patungkol sa same-sex. Hinantulad ko po kasi yan sa pagbabasa ko ng Ruth 1:14, yung isang babae...
Question, ano po yung sinabi? Pagbabasa mo?
Ruth 1:14 po. Yung pangako po ni Naomi kay Ruth, yung wherever you go, I shall go.
I'm sorry, Reverend. Pakiulit, ano yung sinabi mo? Ruth?
Ruth 1:14.
Rule?
Ruth. The book of
Ruth.
Ruth. At similar po dun sa Genesis 2 na ginagamit po din sa teolohiya ng pag-aasawa. Yung nag-cling when yung lalaki mag-cling sa babae at magsama sila.
Can you share with the court, ilan po ba ang membro ng simbahan po ninyo?
Maliit pa lang naman po kami, hindi pa...
Bigyan nyo kami ng numero.
Umabot lang po kami ng 25 tao po. Kamen ko naman po yung iba.
25?
Yes.
Lahat ba ay LGBT?
Karamihan po, bisexual, gay, and straight.
Straight. Kayo ba ay may mga seremonya din?
Yes po. We have two sacraments. We have 2 sacraments and 5 rites. Yung 2 sacraments po namin is baptism and Holy Eucharist. Yung 5 rites po is ordination, Holy Union, memorial service, blessing, at saka po church membership.
Yung memorial service po ninyo ay regular every Sunday or...
Sunday worship po, yes po. Ano po kami? Ang tawag po sa pananambahan po namin ay Sunday worship service.
You have Sunday service?
Yes po.
At saka ito ay, saan po ang simbahan nyo?
Sa house church pa lang po kami, hindi pa po kami merong physical church. Kami po yung nakatira sa number 4, Ali 24, Project 6.
Maraming salamat, Reverend. Can I have Councilor Mr. Falsis back? Counsel, now you heard from Justice Bersamin, who is the acknowledged expert of this court with respect to procedure. And I hope you understand that what he was trying to impart to you. And I will take off from where he finished, and I hope you take what I say as a constructive way to help you. Because humahanga po ako sa iyo, you are committed to your cause, to what you call the movement. And kayo po, kailan po kayo nag-graduate?
Ng law school, Your Honor.
Sa UP, ano?
Yes, Your Honor. 2014, Your Honor, sa UP.
2014. Kailan kayo pumasa ng bar?
2014 po ako nag-bar, and the results were announced in 2015.
And then after that, in short order, nag-file ka nitong kaso, and they are what we call a public interest lawyer.
Yes, Your Honor.
Right. You in fact, have not joined a regular law firm that is committed to making a profit.
No, Your Honor. I'm not part of any law firm.
Kaya po ako ay humahanga sa crusade mo. But just like Justice Bersamin, and I hope you take this, as I said, constructively, I'll go straight to napag-usapan na yung standing. I'll go straight to hierarchy of courts. Meaning, on top of standing, and I'll put it directly, you should have brought this case first to the RTC. And I'll tell you why. You are claiming that there is a fundamental right for persons of the same sex to get married, right?
Yes, Your Honor.
Now, but before you get to fundamental, you have to prove first that there is a right.
Yes, Your Honor.
Yes. So you have to prove two things. Before umabot ka sa fundamental, kailan may right muna?
Yes, Your Honor.
Tama. Now, you have three grounds, your own petition: due process, equal protection, and the right to found a family. I'll just take one so that we don't take too much time. Due process of law. You are using the due process provision of the Constitution. No persons will be denied
Life, liberty,
or property without due process of law. And then your assertion, among others, many, is that same-sex couple can raise children equally competently to be good citizens as heterosexual couples, right?
Yes, Your Honor.
That is your assertion. That is your argument to the court today, right?
Yes, Your Honor.
The government is contesting that. In effect, they're saying the Congress is limiting a family to a heterosexual couple. So the disagreement is, are you correct or is the government correct?
Your Honors, we are of the submission that...
No, I know that is your submission, but you have a difference of opinion with the government, right?
Yes, Your Honor, if with this court's indulgence, this court is the one that disagrees with the government in past cases, Your Honor, when there are cases involving homosexuals.
No, that is why I just like Justice Bersamin, I think I have to tell you very carefully and very slowly what I feel you're missing about hierarchy. Hierarchy means if there is a difference of opinion yung dalawa yun eh. You have to prove it by facts. So the factual issue to support your claim of a constitutional right is, your proposition of fact is raising children by same-sex couple is as good as raising children through a heterosexual couple. I'm saying, and I agree with you, that is a very important question. But hierarchy of court means that has to be tried before a judge, not by oral argument by you and the government, before us. Because you can give your opinion and the government can give an opinion, but I want to hear what are the facts on that assertion that same-sex are as good parents as different-sex couple. Do you understand what hierarchy of court means?
Yes, Your Honor.
Yes. Now, because a while ago, you mentioned separate but equal, right?
Yes, Your Honor.
Anong case yun?
Brown versus Board of Education.
Of Education. Who was the ponente?
The name of the ponente escapes me, but it is a Chief Justice, Your Honor.
Earl Warren, di ba?
Yes, Your Honor.
Oo. Who was a governor before he became a Supreme
Justice.
Court Justice. Now, what was the issue in that case? Para mabilis.
Your Honors, whether the segregation or separation of blacks to black schools and white people to only white schools is a valid government act or
Yes, because many years back, because of what old case? Plessy versus Ferguson, the government was saying, it's okay that blacks go to black schools and white kids go to white school. Kaya nga ang tawag doon ay separate but equal. Provided the facilities in the black school are equal to the facilities in the white school, you can separate the races, right?
Yes, Your Honor.
And who brought the case to question that? The NAACP, right? National Association for the Advancement of Colored People, right?
Yes, Your Honor.
And who was the staff attorney of the NAACP that shepherded the case all the way to the Supreme Court?
If I may guess, Your Honor.
Nako, mapapahiya ka sa taga-UE, College of Law. Who? Thurgood Marshall, who became
Justice.
a justice. Now, did Thurgood Marshall go direct to the U.S. Supreme Court?
No, Your Honor.
That is the point of Justice Bersami. And my point, you should read, there are many books on how they shepherded, how they planned, how the NAACP, I forget now over how many years, planned that case. And they had a lot of evidence, as in testimonial evidence, on the psychological effect of separate but allegedly equal schools. So do you get my point about why you should be better off trying this case before the RTC?
Yes, Your Honor.
And now that you have heard, because I think you are in grave peril that your case might be dismissed. And I'll give you another good example. That is why I ask questions from Reverend Agbayani. Even if the church remains as a party with standing, do you know why I asked that series of questions of him?
Because, Your Honor, what he was saying were factual issues, Your Honor.
Yes. And what does Escritor tell you?
In terms of religious freedom, Your Honor?
Yes. What does Escritor with respect to hierarchy of courts tell you?
Estrada versus Escritor remanded back the case, Your Honor, to the lower courts for...
No, Escritor tells you, and you should reread it carefully, the religious claim is based on religious conviction, right?
Yes, Your Honor.
Just like a fundamental right, religious conviction. Bago ka dumating sa conviction, the first word is religious. That's why I was asking, is there a religion? Is there a religion to start with? Now, what is the difference between a religion and a sect? How many people comprise a religion? Can you have a religion of one? That is described in Escritor. That's one. Is there a religion? Number two, Escritor says, is the claim, burden, being put by the government something that impinges on a practice or belief of the church that is a central tenet or a central doctrine? You have to prove that in the RTC. That was I was asking. That's why I was asking what is the tenet of MCC, what is the different tenet. And you have to prove that. And the question, for example, a while ago, you were asked by Justice Leonen, what is the history of marriage in the Philippines? You have your view, right? The government has a different view about the history. And if I just listen to you, you will give me your views, and if I just listen to the surgeon, he will give me his views. What I'm saying is, the court needs a factual record where experts testify subject to cross-examination. Yun po ang ibig sabihin ng hierarchy of courts. So, just in case your case is dismissed, I hope you will have learned the lessons about why it is important to first try your case. Now, over Jeffel, how many years did it take to litigate?
Your Honors, there were same-sex marriage cases before Obergefell, and so if we include those years before it led to the culmination of Obergefell, it would probably be around 30 years, Your Honor.
30. 30. I'm still looking for a book that will describe the drama that led to Obergefell, but I will lead you, there's a very interesting article of the magazine, The Atlantic, which describes it. And it names a person by the name of Evan Wolfson, I think, as the lawyer, and he was a very young lawyer, who was the shepherd of this case. So again, the lesson is, in Obergefell, you have 4 states. Ay dumaan yun sa district court, dumaan sa Court of Appeals before it went to the Supreme Court. Now, pop quiz in constitutional law. Passive virtues. Who said that?
Passive virtue.
Passive, as in passive versus active. Passive virtues.
Your Honor, the answer escapes me.
Alexander Bickel. What is his book? The Least Dangerous Branch. They don't teach this anymore, no, in the College of Law. Nung time namin, they did. Professor, later, Justice Vicente V. Mendoza. The Ashwander rules, you recognize it? Ashwander versus TVA, Justice Brandeis.
No, Your Honor,
You
unfortunately.
cannot, these are the 7. Ashwander, nakakaya sa graduate ng UE, oh. These are the 7 rules of avoidance of Justice Louis Brandeis. Now, the final question, who said this? And I will quote to you. For myself, it would be the most irksome to be ruled by a bevy, B-E-V-Y, bevy of Platonic guardians. Even if I knew how to choose them which I assuredly do not. Ulitin ko po, ano? Quote, for myself, it would be most irksome to be ruled by a bevy of platonic guardians, even if I knew how to choose them, which I assuredly do not. Do you think we are a bevy of platonic guardians? In your view?
Your Honor, it depends on the meaning of platonic guardians.
I'm sorry? What is your answer?
Your Honor, it depends on the meaning of platonic guardians.
Platonic guardians means they are very learned people and they guard. They're the guardians. They're the guardians of the people.
Guardians of the Constitution, yes, Your
Yes.
Honor.
So, who said this? It's a famous judge who never became a
It's probably, Your Honor, just Judge Learned. Huh?
learned hand, right? Oh, redeeming, huh? UP. This is my last point. There is a pending bill in the House, at least, on civil union. And do you know who is the sponsor?
There are two main sponsors, Your Honor, Speaker of the House, Alvarez, and Congresswoman Geraldine Roman.
So the main sponsor is the Speaker of the House. Now, that is as clout can be. It's the Speaker of the House. Now, at the next State of the Nation address in July, the committee of the Constitutional Revision Committee of Chief Justice Puno is going to submit a proposal to the President on revision, on constitutional amendments, right?
Yes, Your Honor.
Now, a while ago, you had a running debate about the meaning of the two paragraphs in the in the Constitutional Commission of 1986 about same-sex marriage. So what I'm telling you is all of the quotes I told you is about, when we were in the College of Law, we were taught that there are times when this court has to stay its hand. And I am telling you that, in my view now, unless you convince me otherwise, it seems to me that this bevy of platonic guardians should think about waiting for action by Congress and the Constitutional Convention, or which is just around the corner.
Your Honor, with this court's indulgence, and thank you for the opportunity to convince the Honorable Justice. However, we would like to submit that, again, when it comes to fundamental rights, Your Honor, they depend on the outcome, they do not depend on the outcome of an election, and they cannot be the subject of a vote. As long as the Constitution says, Your Honor, that no person shall be denied equal protection of the law, even if there are political movements to offer or correct that inequality, Your Honor. If this honor believes that change is just around the corner for LGBT people in the political branches, that time, Your Honor, is very important for LGBT people, because that time they could meet a lot of problems where without marriage they will be in grave danger, Your Honor, such as if somebody is in the hospital or if somebody dies, Your Honor. So while a lot of people may be able to wait, Your Honor, a lot of LGBT people as well cannot wait, Your Honor. And the Constitution is no respecter of political movements as long as the fundamental rights are enshrined in the Constitution. And the bevy of platonic guardians, Your Honor, we agree to this, but our Constitution is different from the United States Supreme Court and from the U.S. Constitution. This Honorable Court itself has said that Article 8, Section 1 has made this court to be more active compared to its other counterparts. That it is not only a power to decide actual cases or controversies, it is also a duty to determine if there was grave abuse of discretion. So, Your Honor, I concede to the wisdom of the Honorable Justice that petitioner alone, and even as a counsel in his career probably made mistakes during the handling of the petition, Your Honor. But we will answer that in the memorandum, Your Honor, and the petitioner is still of the belief that there were Supreme Court decisions that would help him otherwise. But disregarding the mistakes of petitioner, Your Honor, that there are actual LGBT couples in this case who will be harmed if their fundamental rights are not recognized.
Can I say something? You know, what is ironic about your case? You make yourself, in fact, the lead plaintiff. And in fact, you can wait. In fact, you have been waiting. You don't want to commit to a partner because you want to wait for this court. So I'm saying, the court, I'm saying naman, why don't you wait a while for the Congress and the CONCON to settle this matter. So, pagigihan niyo po sa memorandum niyo because I will be very candid to you as a graduate of the same school that at this point in time, I am more inclined, I think, to dismiss your case.
Your Honor, if I may also just have one last submission, Your Honor. Even though I am young, Your Honor, and it seems that I can wait, Your Honor, but the right to marry creates a lot of ripple effect for people like me who are of a young age, and especially those who are younger. Without the right to marry legally recognized for LGBT people, what message, Your Honor, does it send to young people, younger than me, who experience certain problems in their life, such as, especially in the worst case scenario, depression, Your Honor, or which can lead them to commit certain acts which we do not want to happen. There are messages, Your Honor, that the deprivation or denial of the right to marry sends to LGBT youth. And so I agree, Your Honor, I can wait. But, Your Honor, I would like to impress upon this court that I am privileged.
Anybody with questions? Yes, Justice Leonel.
Just very briefly, a petition for intervention can be filed separately. Is that not correct?
Yes, Your Honor.
And because it's filed separately, it is completely a separate opinion, a separate petition, correct?
Yes, Your Honor.
Because it's parties and cause of action, right?
Yes, Your Honor.
When a court adopts it or allows a petition for intervention to be an intervention, the parties are not second class, correct? They become full parties to the case, right?
Yes, Your Honor.
And we have a catena of jurisprudence that actually say that. An intervenor is no longer simply an intervenor asking for leave to intervene, but once allowed, it is already a party. Is that not correct?
Yes, Your Honor.
So in your case, you may not have an actual case, but is it possible that the intervention has an actual case?
Yes, Your Honor.
Yes, of course, there is a differing opinion from the Solicitor General, which we will hear when the time comes. But another question. The requirement of an actual case, is it essential also for the exercise of the extraordinary jurisdiction of this court? The extraordinary jurisdiction as referred to in the case of AMCOW, written by Justice Brion, and also Araulio versus, I think it was Executive Secretary by Justice Luke Bersamin.
Your Honor's petitioners submit that an actual case
is always necessary because
is still
the
needed.
fundamental constitutional order requires that this court not be advisory, correct?
Yes, Your
Until
Honor.
the Constitution is changed, this court only acts upon real controversies. And there must be sufficient adversariness on the part of the parties and on the timing of the case. It must not be moot, it must not be premature, okay? Now, on the other hand, mention was made of Alexander Bickel. You're familiar with the author, right? You have to. You're from the same school as we are. Yes, the least dangerous branch of government, correct?
Yes, Your Honor.
Yes, I am tempted to ask who your constitutional professor is, but I want to invoke, it might be self-incriminatory on my part, I hope not. But in any case, Alexander Bickel's book is The Least Dangerous Branch, and he had this concept of the court as an anti-majoritarian institution. Is that not correct?
Yes, Your Honor.
And in constitutional law literature, it is the most debated concept, whether the court must be called anti-majoritarian or not. But there are some, let us say, experts or scholars that actually say that courts also fill in a democratic deficit. You
Yes,
agree with
Your
me? For example, you're familiar with the name Mark Tashnet, correct? Mark Tashnet is a constitutional law professor teaching where?
Your Honor,
Just look at Justice Hardelesa, the alma mater of Justice Hardelesa, which is from the Harvard.
For the record, he was not my student.
Okay. I think...
He is too young to be...
Anyway, Mark Tashnet is a professor in Harvard, and commenting on the case of Obergefell, the title of his recent article is Equal Dignity. And his point is that it corrected the anti-subordinate position. The case was an anti-subordination case, quoting another author, saying that it corrected a deficit in democracy because there are marginalized identities in society, people who prefer not to out themselves because there is cultural oppression out there.
yes,
Okay?
Your Honor.
Yes.
And
And in
if
the
I may-
case of the LGBT community, it is usually the case that the cultural majority cannot accept them, correct?
Yes, Your Honor.
Or that even families are difficult to convince, correct?
Yes, Your Honor.
And therefore, one of the most tremendously emotional moment of an LGBT person, a lesbian, a gay, a bisexual, a trans, or what you might want to overall call a queer, okay? One of the most passionate, emotional moment is when that person comes out to his or her family, correct?
Yes, Your Honor.
And state, for the record, is gender identity, the gender expression, or the sexual orientation, correct?
Yes, Your Honor.
If it's difficult for the family, all the more it is difficult for the society, correct?
Yes, Your Honor.
You're familiar with DSM.
It is the classification of medical illnesses by...
Prior to 2013, that late, the DSM carried a disorder called gender identity disorder, correct?
Yes, Your
It was
Honor.
only in 2013 when DSM-5, the Diagnostic and Statistics Manual for Mental Disorders, removed that in recognition that gender identity, gender expression, and sexual orientation is not a mental disorder, correct?
Yes,
There is
Your
no
Honor.
chemical imbalance, there is no symptom that essentializes who people are, and therefore up to 2013 it was even considered with all its symptoms as a disorder, correct?
Yes, Your Honor.
So you are faced with a situation where when you go to a political majority such as Congress, it is a long stretch, correct?
Yes, Your Honor.
Yes, and a long struggle, correct?
Yes, Your
As
Honor.
in many countries, correct?
Yes.
Yes, but on the other hand, the other argument is it may be more stable for a political majority to start its recognition no matter how difficult it is. It may be more stable than when a court does it, correct?
In certain instances, yes,
Yes,
Your Honor.
or sometimes it's the court that triggers it, right?
Yes, Your Honor.
Like in the case of slavery, like in the case of desegregation, like in the case of the New Deal, like in the case in the Philippines of the PDAF, like in the case of indigenous peoples, overturning that mention in Ruby versus Provincial Board, Cruz versus NCIP, and so on and so forth, correct?
Yes, Your
So
Honor.
it's a fine balance, right?
Yes, Your Honor.
And it depends upon the skill and the brilliance of the advocate that is bringing it to the court, correct?
Yes, Your Honor.
Yes, and of course, we would like to see the skill and the brilliance in the memoranda. Of course, it must be discounted and balanced against the skill and the brilliance of the Solicitor General. Is that not correct?
Yes, Your Honor.
Who to this point has not yet lost a case in this court, right?
Yes, Your Honor.
Yes, and it may be that you will hand him his first defeat, correct? We are hoping, you are hoping But of course, it will depend on how this court will rule, and probably you will listen to the procedural arguments, because I think in this case, it is of such importance. Because this court, I think, wants to defer to the political organs, more than the political organs may want to defer to us. But on the other hand, it is important that you address these points. Finally, are you familiar with the Yogyakarta Declaration?
Yes, Your Honor.
Yes. It is a declaration of several experts on the interpretation of human rights, correct?
In international law, yes.
In
Your Honor.
international law. And you were asked a while ago whether there is an international instrument that moves towards gender equality and not only sexual equality, correct?
Yes, Your Honor.
But there are already some movements in international law, right?
Yes, Your Honor.
Including the CEDAW.
Yes, Your
Including
Honor.
some committee reports in the CEDAW.
How the convention...
Probably in your memoranda, you will not miss it the same way that you missed it a while ago when you were given the opportunity to discuss it, correct?
Yes, Your Honor.
Yes, thank you, Counsel.
Counsel, I have a few questions. Did I hear you right that this church, that petitioner C.J. Agbayani has been performing same-sex marriages for some years now? Is that correct?
Yes, Your Honor.
And I suppose Reverend Agbayani has a permit from the Civil Registrar General to perform marriages.
Your Honor, what they perform is called the rite of holy union.
So he performed a marriage without a marriage permit, that's what you're saying? No permit from the Civil Registrar?
Marriage, Your Honor, in the legal sense, he did not. If marriage under the church as a holy union, yes, Your Honor.
Yeah, well, let me rephrase it. Did he submit to the Civil Registrar General's office the marriages that he performed? Because all pastors authorized to solemnize marriage must submit a report. Did he submit a report to the Civil Registrar's office?
As far as counsel knows, Your Honor, he did not, because he did not even contemplate of doing such, given that there is no law or practice that he knew that would allow him to do such.
So there was no chance for the Civil Registrar General to refuse to accept the report on the ground that it's a union between same sexes.
Yes, Your Honor.
Okay. Now earlier you said that you're not happy with the bill in Congress, although the bill of Speaker Alvarez grants all the rights to same-sex marriages. You're not happy with the terms civil union. You want the marriage between same sexes to be called a marriage. Is that correct?
Your Honors, we are happy with the movement to grant rights to LGBT
No,
people.
happy with the bill.
But the bill itself, if it passes, would indeed make us happy, but not as happy, Your Honor, if the term used was marriage.
Okay, it's only because of the term you're not happy with the bill. The bill should call the union between same sexes as marriage also. That's what you want.
Your Honor,
Otherwise, everything is okay.
if the content of the civil union bill is the same, Your Honor, as the content of marriage under the family code, then, Your Honors, our submission is then the term must be the same.
Oh, so because you said earlier that the bill grants same-sex marriages the same rights as opposite-sex marriages, but only the term is different.
Yes, Your
Is
Honor.
that correct? Now, the term marriage has historical, biblical, and social origins. It's between man and a woman. That's the connotation. When someone tells you, oh, he's married, what comes to your mind is a marriage between a man and a woman. So we are now, if Congress will recognize a union between the same sexes, we must give a different term because you don't want to confuse people. When you say, oh, they're married, then you will be thinking, do they belong to the same sex or are they opposite sexes? So there's a substantial distinction, historical, and also you want to avoid confusion. So, would you not accept a different term for same-sex marriages as a civil union or some other term? Because all the rights are the same. You're saying all the rights are the same under the bill.
Your Honors, if Congress passes a law to that effect, then we would accept it, Your Honor. However, if the only question so far is, given the same terms and conditions that exist in the law right now, then there is no term that is civil union. And so, Your Honors, we are for the equal rights to the
But there's a substantial distinction. Marriage is defined as a union between a man and a woman ever since. We are now recognizing union between the same sexes. You still want to use the same term, but it will confuse people.
Your Honors,
You should be happy to make a distinction because there are substantial distinction. They are different sexes.
petitioners see the point of Your Honor. We would just like Your Honor to mention the fact that even under Philippine history, Your Honor, that the term marriage was also used by babaylans, and that it was the colonization era that erased that history. There are some scholars to the effect that the community accepted babaylans who were men but performed gender expressions of women to marry, quote-unquote, fellow men, Your Honor.
But we have to have because it's a different union, it's between sexes as against the opposite sexes, you must have a different term.
We submit.
Anyway, the rights are the same. Okay, right now, is same-sex marriage being performed by the Reverend C.J. Agbayani, is it a crime?
No, Your Honor.
It's not a crime. Is it a ground for disqualification to hold public office if you entered into a same-sex marriage?
No, Your Honor.
Is it a ground for dismissal from private employment?
For some employers, there have been
No,
instances.
but is it a legal ground?
No, Your Honor.
So it does not disqualify the parties to a same-sex marriage from civil and political and business rights, correct?
On the one hand, yes, Your Honor.
What are the disqualifications?
To clarify, Your Honor, I only meant that on the other hand, there are legal rights or benefits that they could not access.
Okay, let's go into that. Can two parties to a same-sex union adopt by written agreement the absolute community of property? By agreement, can they do that?
Yes, Your Honor.
By agreement, can the parties to a same-sex marriage name each other as their heir, as one another's heir? So there are successional rights by agreement.
Limitedly, yes, Your Honor.
So we take care of succession rights. They can designate each other as their heirs. The community of property, they can adopt it. What else? What will be the legal problems?
Your Honors, we would like to go back a bit to the question of inheritance. Only the free portion will same-sex couples be allowed to fully grant to their partners now. The other problems, Your Honor, without marriage is first joint adoption of children, either those in
Wait a minute. We go to inheritance. The same-sex marriage, they don't have children, assuming they have not yet legally adopted anyone. One can designate the other as the heir. Is there a problem there?
Your Honor, the compulsory portion of the estate would go to the parents if the
Ascendants.
parents are alive or
The
their
ascendants.
siblings. Yes, Your Honor. First, before the partner. And because
So-
the law is compulsory, then any contractual arrangement, including an inheritance, which stipulates that all of the person's
Yes,
inheritance.
but if they have adopted the absolute community of property,
Your Honor, there is no
agreement.
case that guides, I think, the court and lawyers that there is such a ruling to that effect, that same-sex couples who have entered into an absolute community of property outside of marriage in a legitimate contractual relationship can deprive the compulsory portion of a person's estate.
Okay, so you have that problem because of the legitimate of the ascendants, because you're not talking of descendants because they don't have children.
Yes,
if they
Your
have
Honor.
children, they can legally adopt, and the children can be their heirs, correct?
Yes, Your Honor. To further on that situation, Your Honor, if a same-sex couple have children that they adopt, only one of them could adopt, and in relation with inheritance, the other partner is a legal stranger to the adopted child. And we have a plethora of cases where the adopted child has no relationship at all with anyone except the adoptive parent, Your Honor.
Okay, we recognize that issue. What are the other legal problems?
Your Honor, the benefits from compulsory government contributions like SSS or GSIS, which has a priority list of
Yes,
of
there are
people-
primary beneficiaries, but if there is no legitimate spouse, there are no legitimate children, then you go to the secondary beneficiaries. The number one there will be the parents of the deceased.
Yes, Your Honor.
So that requires only a small revision in the law. Because the member of SSS GSIS can designate someone if he does not have legitimate children or legitimate spouse, or he has no more parents, he can designate any person.
Yes, Your Honor.
Okay, what are the other problems?
Your Honor, when it comes to hospital and visitation rights, if a person is not legally married to another person, the family and the next of kin are the legally mandated persons to have authority to make decisions in cases of life or death, or where the person cannot make a decision for him or herself. Aside from that, Your Honor, such as what was mentioned a while ago in the case of Valino versus Adriano, a same-sex partner will be treated as a mistress in the event that a family wants to arrange the funeral or conduct the burial in one way versus the partner of the deceased person. Under the Civil Code, there are individuals who are mandated by succession to have the right and duty to bury their next of kin.
Okay, what else?
On top of my head, Your Honor, those are the things.
Yeah, but
I
you
can think
you should know everything about this, because this is what you're talking about, same rights. So if you're only mentioning 3 or 4 items, I think it will not be too difficult to amend those laws. Okay. There is a pending bill in Congress to give same-sex marriages the same rights. Can't you not wait for that to be passed?
Your Honors, as I was saying with the discussion with Justice Hardilesa a while ago, personally, I can wait, and a lot of other LGBT people can wait, Your Honor. But those people who can wait are privileged people.
When was the bill first filed in Congress?
It was only filed, Your Honor, in 2017 or late 2016, Your
Yes,
Honor.
so we're talking only of this Congress. It has not been filed before, so this is the first time.
This is the first time, Your Honor, and in the past Congress, there were bills actually that were filed to expressly ban same-sex marriage, if I recall
Yes.
correctly.
So this is the first bill to grant the same rights. And usually the court will wait for Congress to act, because this involves policy issues. And if Congress is considering the bill, we don't want to preempt Congress.
Your Honors, our submission to that is in other cases of constitutionality and fundamental rights. The court did not wait for curative or remedial legislation, such as in the Anti-Cybercrime Act. When a law infringes on fundamental rights cannot be made to wait, Your Honors.
Yeah, but a law was passed already. So you're now questioning the family code, which has been there for some time, since 1987.
Yes, Your Honor.
Okay, so that will be all, counsel. The next, we will adjourn for the day because we're running out of time. It's 6 o'clock. We will resume the oral arguments on June 26, Tuesday at 2 p.m. We will start the oral arguments on Tuesday with the presentation of the Solicitor General. Thank you, counsel. You're excused.
Thank you, Your Honors.
We adjourn this hearing.
All rise. Please remain standing while the acting Chief Justice and the Associate Justices leave the session hall.